Yes, yes, now it's proper, sir. Very good evening. I welcome all of you on behalf of Pusa Road CP Study Circle, or on a very first webinar after the presenting of the new finance bill 2025 by the Honorable Finance Minister Sitaraman ji in the Lok Sabha today. As promised earlier, Kapil Bhai is always ready that whenever the finance bill or some issues come in the Lok Sabha, he will take very first session on the very same day. So keeping his promise intact, yesterday around 12 p.m. midnight, we chatted over the phone and Kapil Bhai is okay immediately. And that's why we are here. And on the board, more than 350 participants are here. I welcome you all. I also welcome Srivastav ji, Rakesh Khivani ji, Atul Puri ji, and especially Dharmender ji from Tanzania, and all the attendee on behalf of our study circle. As you know, we were all professional were waiting since long that when our finance minister honorable said that she will come with a new finance bill next year. And on the 1st February, she again promised for the next week. And from the day one, we were eager to listen or hear or know what would be in the new budget. Ultimately, the budget has come. Oh, sorry, new Finance Act 2025 has come, and lot of hue and cry and WhatsApp ज्ञान is going on. लेकिन we would like to know कि कपिल जी की क्या कहते हैं, कपिल जी इसको किस तरह से लेते हैं. दैट इज द फ्रेंडली टैक्स पेयर और असेसी के फेयर में है या रेवेन्यू के फेवर में है. सुनने में तो बहुत आ रहा है कि इतने सेक्शन खत्म कर दिए, सब सेक्शन कोई नहीं है, एक्सप्लेनेशन कोई नहीं है. लेकिन फिर भी हमने कपिल जी की सही पता लगेगा कि इसमें क्या है क्या नहीं है. तो विद दिस सर, वंस अगेन आई वेलकम यू सर, एंड विदाउट टेकिंग टू मच टाइम. और मेरी सभी से रिक्वेस्ट है, क्योंकि ये न्यू फाइनेंस एक्ट है, बीच में कपिल भाई को कोई डिस्टर्ब ना करे, क्योंकि कपिल भाई का कहना है कि मेरा ना फ्लो रुक जाता है. जब भी कोई क्वेश्चन है उसको संभाल करके रख लें, वो जरूर जाने से पहले उनके क्वेश्चन को दूर करेंगे, सारी जितनी भी मिस हैं उसको क्लियर करेंगे. और एक चीज मैं और भूल गया कि अभी रिसेंटली 2-3 जजमेंट भी बहुत अच्छे आए हैं. वो भी मैंने कहा कपिल भाई को कि जब हम इस पे वेबिनार कर रहे हैं तो उनको भी बारे में भी हमें अपडेट कर दें कपिल भाई. तो कपिल भाई हैज एक्सेप्टेड आवर रिक्वेस्ट. विद दिस वंस अगेन वेलकम सर, एंड ओवर टू यू.
मैं बीच में इंटरप्ट नहीं करना चाहता. मैं ये पूछना चाह रहा हूँ कि हम सारे एक्ट को ले रहे हैं, सारे न्यू बिल को ले रहे हैं, या ओनली दोज विच आर कंपैरेटिबल?
सर हम पूरी साहब ऐसा कोई स्ट्रक्चर नहीं है, बट फिर भी हम ब्रॉड कंपैरिजन जरूर करेंगे कि जो हमें समझ में आया, जितना हम इस आज के एक दिन के अंदर एक्सरसाइज कर पाए, क्योंकि ये तो इवोल्यूशन है, जर्नी है.
ठीक है,
यू कांट डू इट इन ए मिनट, क्योंकि उन्होंने 36 पेजेस के एफएक्यूज दिए हैं अलग और 12 पेजेस के अलग दिए हैं.
ठीक है सर, ठीक. थैंक यू.
मतलब एनी हाउ, लेट अस सी हाउ द थिंग्स गोज, एंड बिहारी जी की जैसी इच्छा होगी. राधे राधे, सबको बांके बिहारी की जय हो. ऑल माय पार्टिसिपेंट्स हियर, पुरी साहब, वेरी डियर रिस्पेक्टेड पुरी साहब, खिवानी साहब, एंड श्रीवास्तव साहब, धर्मेंद्र भाई, और सबसे ज्यादा श्रद्धेय मेरे दोस्त और मेरे परम, मैं जिनको मानता हूं कि भक्त शिरोमणि है, राजेश अग्रवाल जी. और ये जो बांके बिहारी की कृपा है राजेश भाई, हमारे ऊपर ये बनी रहे. आई हैव लर्न सम मोर लाइंस ऑफ भजन्स. आई विल स्टार्ट विद दैट. ये तो प्रेम की बात है उदो, बंदगी तेरे बस की नहीं है. यहाँ सर्दे के होते हैं सौदे, आशिकी इतनी सस्ती नहीं है.
वाह जी वाह.
जो उतरती है चढ़ती है मस्ती, वो हकीकत में मस्ती नहीं है. और जिनकी नजरों में है श्याम प्यारे, और ज्ञानी जी जिनकी नजरों में है मोहन समाए, वो नजर तरसती नहीं है और वो रहते हैं जग से न्यारे. सो ये लाइंस मैंने अभी रिमेंबर करी. और इसी की कंटिन्यूएशन में राजेश भाई,
जी जी सर.
राधा रमन लाल मेरे गिरधर गोपाल, जय जय राधा रमन लाल मेरे गिरधर गोपाल, तेरे अंग संग रहेंगे राधा रमन लाल. और एक मीरा जी का भाव था, मैं गिरधर की और गिरधर मेरे, ये भाव मुझे अभी समझ में आया, कल परसों मैं किसी संत को सुन रहा था, तो उस भाव का मतलब यही है कि मेरे गिरधर की और गिरधर मेरे, मैंने अपने आप को गिरधर को दे दिया और गिरधर मेरे हैं। इस लाइन को अगर हम 10-15 बार बोले तो इसका ऐसा मैजिकल इम्पैक्ट होगा कि आपकी सारी एक्सरसाइज हो जाएगी सर। Sir, Ishwarji, you know English. My majority people are there in Hindi, so I have to go by majority. Although I have no problem in speaking English.
Sir,
क्यों
you
Kiraj?
mix the language, mix the language. Sometime Hindi and English both.
So my good friends of South, I would apologize to them at the outset. If they have some problem, they have to bear with me out, because my majority of people here, Rajesh Agarwalji channel, are from this our Hindi loving people. But still, I will see how can I make it a bilinguistic mode. So this income tax bill 2025. Thank you, Sangai ji. This income tax bill 2025, which has been tabled in the parliament today, cleared by cabinet on 7th January, announced by the finance minister in 2024, and repeated in finance bill 2025. So we have this, Rajesh bhai, the stage of this bill was set in 2024 and 2025. So, Finance Act 2024, the speech of Honorable Finance Minister in 2024, and the present Rajesh Bhai Finance Bill 2024 cleared that finance bill will be, this new income tax law will come. Now, first of all, Kivani Saab, there are some very interesting statistics I have noted down. You can all note down for your just kindly some kind of consumption. We have divided this session in two parts. One is income tax bill. We will discuss broad outline. I can never say, and I will always submit. I have given two caveats. One, I will try to see what I have jotted down. I can definitely converse it with you and communicate. And secondly, if there are some things which are left, because there will be many things which have to be, Rajesh bhai, evolved with the time. This is first day on the bill which we are sitting practically. So one cannot expect, as somebody was saying, na, ki there are somebody myths. You were saying ki myths I will clear. There are various myths which will be clear after a long time. So it will take its own time, I will say rather. So this income tax bill 2025 tabled in the parliament today by the Honorable Finance Minister. Now, you can note down, Rajesh bhai, some very interesting fact, Himani ji, Srivastava Saab and Puri Saab, if you can note. It has been given, there are two important documents accompanying the finance bill, this income tax bill 2025. One is the frequently asked questions running into, sir, 12 pages, and one is 36 pages. And there are a lot of frequently asked questions given, and they are also very interesting reading. I will try to take all of you through some questions, answers, which are important, Rajesh bhai. Some important, significant questions we will take, which have been clarified, Kivani ji, which will definitely throw the light from first-hand perspective, what is their take about it, and then we can debate it as the time permits. Now, some important facts. 1961 law. We are in 2025. Now, this old law of 61, which replaced 22 Act and came in 1962, 1st April 1962. So it has been stated that at least 4,000 amendments have taken place, and 65 times it has been amended. It is the statistics given in the frequently asked question by the Honorable Finance Minister, government, that 65 times, Kivani ji, it has been amended, and more than 4,000 amendments. And it is to be kept in perspective that Mr. Palkiwala Saab and the great legal legendary was there. He used to say income tax is a legislation which is very, what do you say, Rajesh bhai? He used to say, Palkiwala Saab, that this is a legislation which nobody can understand, and it has been so many times amended. It is totally unintelligible and beyond comprehension. तो इसको समझना बड़ा मुश्किल है. पालकेवाला साहब ने इसकी बड़ी कई बार निंदा भी करी जब वो बजट स्पीच देते थे कि हर एक बजट में अमेंड होता है.
वो ये कहते थे कि इवन द मेकर्स ऑफ द लॉ डोंट अंडरस्टैंड इट.
क्या बात है. तो 65 times amended, 4,000 amendments. Now there are how many sections in the income tax law? अगर आप वैसे देखें तो you will see that 298 somewhere sections are there in the Income Tax Act, sir. But what they are section numbering A, B, C, D is there. So we have been given in the frequently asked question, the statistic is this, there are 819 sections in the Income Tax Act 1961. Himani ji, 819, 819. So one may not be confused with 298 figure, which is otherwise there because there are A, B, C, D sections. So 819, now it is 536. So you are reducing from 819 to 536. Likewise, they say there have been 47 chapters. Otherwise, you will find there are 23 chapters. But there are chapters with A, B, C, D number, Puri Sahab. So effective chapters in the 1961 law are chapters in the 1961 statute book is 47. Now there are 23 chapters. So 819 sections, 819 section to 536, 47 chapters to 23 chapters. And words. Now word count, Khivani is very interesting. 5,12,000 words approximately in the old law and 2,60,000 words in the new law. Am I there, sir? My voice is clear? Srivastava ji, am I clear? So
yes, boss, clear, very clear.
Okay. So 5,12,000 Rajesh bhai words in the old law and below 1961 law and 2,60,000 in the new law. 18 tables in the old law, 57 tables. Now this law is very replete with the tables. You know, tables, you know, when we, Kivani ji, kai baar hum jab court mein argue karte hain, many times we argue in the court or tabular presentation helps. So this new income tax bill is having lot of tables and formulas to reduce the size and to bring more clarity and understanding level is increased. So 18 to 57 is the tables. So the another data is 1,200 provisos and 900 explanations are done away with. 1,200 proviso and 900. I just say on lighter side, Rajesh bhai, hats off to the taxpayers and tax consultants and tax administrators and tax judges that they have to understand a law with 1,200 provisos and 900 explanations. And the life of this law is still left 2 years. And litigation is going on various circles, we know. So Srivastava, it's a very interesting statistic which first time has come like this. 1,200 provisos and 900 explanations will be done away with in the new law of 2025. So is in this law, you are having a law contained in 1,200 provisos and 900 explanations. Anyhow, and that's why it is a interesting subject matter to note that how it has increased litigation. Another statistics is this: 60,000 man hours they have said they have employed to draft this bill. 60,000 ghante man hours, 60,000 man hours, sir. You are noting all of this. I have culled out it from various places, sir.
Okay, 60,000 man hours तो कुछ भी नहीं होते भाई. For a law which is going to control the entire country.
But this is said in the bill. I have not said from my side, sir. This is control F करके आप ढूंढेंगे मिल जाएगा. 20, you are right, पुरी साहब, आप सही कह रहे हैं. You are right that Kapil bhai 60,000 में क्या होगा? 20,976. 20,976. अरे छोड़िए Mr. Bansal. Let me be like this only. I don't want to come in. 20,906. We focus on my voice. 20,976 suggestions they say they have received. So Bansal sahab, please just concentrate with me. Be with me. So these are the wide statistics, Srivastava, which have been given. Now, when you see there are no structural changes as such in the law, I was reading this law from the perspective of 2-3 things. When it was said, Rajesh bhai, when they are drafting the new law, it was suggested you can note how new law will be drafted and what is the parameter of drafting. If you want to note, you can note 4 parameters they gave. One is reduction in the litigation. A, you can note 4 parameters they gave, the finance minister. That in the new bill, they have drafted the new law keeping these 4 pillars in mind: the compliance reduction, litigation reduction, obsolete provisions being redundant provisions being removed, and simplification of the language. These are, Rajesh bhai, 4 points. Now, one of the core area is to see that litigation is reduced, compliance burden is reduced, Srivastava, and third is this simplification, and fourth is redundant provisions. If I have to ask myself and answer you as my reading of this 8 hours and last day, I find definitely redundant provisions, Puri Sahab, they have removed. And rightly so, that there were a lot of redundant omitted provisions which were already there, which was still there in the Income Tax Act, like that 269U, etc. They have removed lot of redundant provisions, almost all of them. So that is one of the important aspect, positive aspect of this development. But what is interesting to note is, when this is an epochal, now what is the effective date of this law going to be? This is going to be effective from 1st April 2026. Section 1, subsection 3 of the bill says it will be effective from 1st April 2026. And it will be now tax year being governing. Previous year and assessment year concepts are done away with. So first major major change or will become is tax year. Now the unit of assessment will be tax year. And it is defined in section 3 of the bill of 2025, Rajesh Bhai. Now, previous year concept goes, AY assessment year goes. There is no definition of previous year and assessment year, Srivastava sab, in the bill. What they say, to simplify this, they say all charging section 4, assessment, all actions of tax authorities will be now based upon this aspect of tax year. If I have to tell you what is tax year and how they have suggested is, in question number 1.2 of the frequently asked question, they say, what is a tax year? What does it replace? What was the need for introducing it? What was the term financial year not used in the place of the term tax year? So it is answered like this, Rajesh Bhai, I'm reading quote unquote. A tax year is a period of 12 months contained in a financial year. Number one is a period of 12 months contained in a financial year. It replaces the term previous year used in the Income Tax Act. Further, with the discontinuation of the term income tax assessment year in the Income Tax Bill, now the term tax year will now be used in relation to the rate or rates of income tax also. In addition, any assessment of the income or total income will also be done for a tax year. Use of the term previous year and assessment year were creating confusion in the minds of the taxpayer as they represented two different financial years. No. So they say we are now, the term taxpayer year is commonly used in income tax legislation in comparable tax jurisdictions. बाहर के देशों में, in various foreign countries, the tax year concept is used, so they have brought. So this is interesting change and positive direction change. They are bringing it to tax year, and they say that it is comparative jurisdiction में पूरी सब that is used, and they say previous year and assessment year concept they will done away. But the important aspect to be taken note of here is question number 1.5. What will the concept of tax year conflict with the concept of assessment year at any particular time? For example, if the new act comes into effect from 1st April 26, will the tax year 26-27 of the new act conflict with the AY 26-27 of the Income Tax Act? Answer is no. Now, this is very important answer given, Rajesh Bhai. This law, when it talks about it takes effect from 1st April 26, it means tax year 26-27. That is corresponding to financial year. So it meaning thereby, in simple terms, the accounts and the assessment till financial year 31st March 2026 will be done as per the Income Tax Act 1961. This is written in the, Jindal sir, swagat hai aapka. This is written in question 1.5, sir, Ramnam. 1.5, and it is clear. Am I clear, sir? This is very important concept, Puri Sahab, tax year and the implication of 1st April 2026. So you have some breathing space. It will not be effective immediately.
मगर कपिल भाई इन्होंने कहा है कि कंसिस्टिंग ऑफ 12 मंथ्स स्टार्टिंग फ्रॉम एंडिंग नहीं लिखा है कहीं पे भी.
सर वो 12 मंथ्स का पीरियड वो उसी को डोनेट कर रहा है. आप तो सेक्शन 3 की परिभाषा, if I read section 3 of the finance, this income tax bill 2025, then you will be very clear, sir. You can read, this says, for the purpose of this act, tax year means the 12 months period of the financial year, 12 months period of year commencing on 1st April. And if the business is newly set up, then it will be date of setup which will be counting. Then tax year can be less than 12 months. Generally, it will be equal to 12 months. And therefore, section 4 charging section now replaces and accordingly changes in the entire law. Section 4, which is the charging section in the 1961 Act, and also charging section in the Income Tax Bill this 2025, is the denominator is common denominator is tax year. So this phraseology, Rajesh Bhai, tax year should be clear to all of you. Various articles in the newspapers are coming, Economic Times, Hindustan, all these news. I have also gone through them. But my humble submission is this, this concept will be definitely important for the taxpayers when they will make compliances in the new law of 2025. And when this bill is coming, there is a process. Now, this bill will be recommended to parliamentary committee, and then it will come back and suggestions will be taken board. Then the parliamentary process will take place. Then only new law will be implemented. That's why the date has been kept 1st April 2026. Are you there?
कपिल भाई से एक एडवांटेज हो जाएगा. वो लिखते थे ना, it will commence from 1st April. तो उस पे ये कंफ्यूजन रहती रही कि फाइनेंशियल ईयर 31 मार्च वाला अगले साल में होगा कि इट विल बिकम इफेक्टिव फ्रॉम 1 अप्रैल 20।
Only
अब
for
ये
compliances, sir, you're right. Only for
हाँ.
procedural compliances, they have referred financial year at some places. So they have clarified why they have retained previous year is gone, assessment year is gone, but financial year is retained for for example, some procedural compliances have to take place qua financial year. Then they have said that that's why immediately we have used financial year. Are you getting? And this is clarified in one of the frequently asked question, Rajesh bhai. So first aspect was tax year, sir. And one of the important aspect, tax year aspect, and this applicability date of the new law will be 1st April 26, subject to it becoming the law. And it passes through the, parliament and it is enacted law. Then only it can come into force. And that's why they have also said it will be, when it will become the act, then it will only operationalize. And 1st April 26 is kept as the date in section 1, subsection 3. Now, one of the important thing which I was looking, Puri Saab, is very interesting statement of objects and reasons of this law. Should I read that? It's very interesting of this. Income Tax Act passed in 1961 has been subject matter of numerous amendments since its passage 60 years ago. As a result of these amendments, the basic structure of the Income Tax Act has been overburdened and language is becoming complex, increasing cost of compliance for taxpayers and hampering efficiency of direct tax administration. Tax administrators, practitioners, and taxpayers have also raised concerns about the complicated provisions and structure of the Act. I am reading from Statement of Object and Reason, SOR we say in our short language, of this Income Tax Bill 2025. Therefore, government in the budget in July 2024 announced that a time-bound comprehensive review of the Income Tax Act would be undertaken to make the Act concise, lucid, easy to read and understand. Accordingly, the Income Tax Bill has been prepared, which proposes to repeal and replace the Income Tax Act 1961. The last section, now this is very interesting. So they say a lot of amendments have taken place to make it user-friendly and reading-friendly. That's why they are bringing it. And that's why they have the statistics, 1200 provisos, 900 explanations, all those things, 5 lakh words to 2 lakhs words, and all these things. And section 536 till 536. And 536 is the last section, which is containing various repeal and saving provisions, sir. So it will, Puri Saab, so that there is smooth transition from the old law, 1961 law to 2025. There is a very detailed section 536, which has been made, which is containing numerous contingencies. I am not boring you because that requires another, I'm broadly telling you. It contains, just say, for example, some proceedings initiated and are taking place in the 1961 Act. They will continue and they will be governed by 1961 law. And some deductions given in the new law or old law will continue and will be treated in the new law as if it is given in the new law. So there is a proper repeal and saving clause in section 536 of the Income Tax Bill 2025. Now, statement of object, I have read tax year, I have told you, sir. One interesting thing, Puri Saab, when I told about these 4 pillars, compliance reduction, litigation reduction, simplification of language, and obsolete provision. Simplification, I can say there is there because they have replaced the word notwithstanding with the irrespective word. Now, notwithstanding word खिवानी जी नहीं है, irrespective लिखा है. थोड़ा हिंदी भी बोलना पड़ेगा सर, वरना आनंद नहीं आता.
सेटिस्फेक्शन ऑफ एओ है कि नहीं है
सर वो है, जिंदल साहब है. वो कहाँ जा सकता है बिना उसके, what you are saying is कि गोयल साहब, satisfaction of assessing officer is present in the bill. It is present, sir. It will always be there, sir, because it is AO-centric law. To complete your point, how can income tax law or any tax law can become complete otherwise if AO will have no that discretion and satisfaction? What do you say, satisfaction?
अश्विनी जी, उसके पास एक ही तो हथियार है. The explanation has been heard but not found tenable.
Anyhow, sir, just let me compare the points, some important points. Or one important thing, Rajesh bhai, when they say that it has to be, litigation has to be reduced, the basic question comes in the mind of various people is, I was reading various articles, Puri Saab, thoughts of various great learned scholars. And I treat myself as the least one, no scholar, nothing. But when I was reading through with this bhavna, the views of various great people in the newspapers, they were saying, many of them will be saying that this law, which Rajesh bhai, should have made the exercise smoothened for taxpayer as far as less litigation is concerned. Those very important reforms are not there, Srivastav. Like, for example, I have made a list, you can note down, and I have to make a lot of hard work for this also. For today, I was penning down what is missing. Puri Saab, it may be very interesting and you will appreciate, that what is missing in this, all these 530, in this grand change. What is this could have been done and still it can be there. For first thing which I found, Rajesh bhai, if you want to reduce litigation and if you want to, Srivastav sir, make the life of taxpayer really easy, then you have to have accountability provision. You have to have a provision which enforces taxpayer charter. Just making taxpayer charter does not help anybody. If there is no mechanism to enforce the taxpayer charter, Jindal Saab, there is no sense of it. If you say that you have a mechanism of taxpayer charter, there is a section in the income tax bill, section 240 in the 2025 bill. But I am asking a question, unless and until there is a proper enforcement mechanism and to pull the wrong person, what is the use of that charter and how it is going to help us? And there is no accountability at all at the end of the day, because why I am talking about all this, there are great judgments by great judges of our court, which have been saying that administration in the country, like Padiwala Saab, B.V. Nagrathana Madam, and this judge Narsimhan Saab, all these three judges of Supreme Court in three different judgments, Rajesh Bhai, have said accountability of bureaucrats should come. Can you say making the law easy and simplified, and unless the intention, Srivastava Saab, you all are more simple, unless the intention is there, unless that mindset is there, unless that approach is there, unless that kind of use na ki trust first and scrutinize later, trust approach is there, how can you? And you have that mindset to have target assessment. You have ki aap ek bar kar dijiye, you do one time and let the appellate court and writ court decide. Is it without accountability, without having enforcement mechanism to plug wrong officials? Can you say that this exercise can be reached to the Rajesh by right logical end? That is point number one. Point number two, my favorite two sections, one brother was also definitely talking about, I will take that 148 wala, because judges in the High Court also started. I have told, Rajesh bhai, Delhi High Court, our Verma is saying, Mr. Goel, why don't you now, he has given me a point, why don't you write book? I don't know any art to write book. I don't know how to speak. He says, you are expert of 148, king of 148. I don't know what he says means. He's making me, what do you say, happier or kidding? Hai Kevani ji? So at one time, I find myself that 148 can never leave us. Yes. And this is Verma Saab's blessings. But that apart, I am telling you that when this is one accountability aspect, Puri Saab, which is baffling me why it is not there. Second is this section 68 to 69D corresponding sections. You know, section 68 to 69D, if I make a humble generalization, Rajesh bhai, section 68 to 69D have been the provisions which have been used in almost every second case. Am I right, Kivani ji? That these are, we have discussed this many times here also.
Yes.
Because Jindal Saab, what happens the moment they apply section 68 to 69D, there is a section in the Income Tax Act 1961 115 BB 60% tax rate that is there, and it goes beyond 100% also if interest and etc. is included. Now, I was very curiously comparing Puri Saab, section 68 to 69D ka parallel. What is the corresponding provision in the new income tax bill of section 68 to 69D? You can note section 102 to 107. क्या नंबर चेंज हो गया राजेश भाई? 102 से 107, मतलब 68 to 69D unexplained income section, 102 से 107. And Srivastava sir, one interesting change which frequently asked question plugged out. I could not, maybe they say 68 heading, you know, unexplained cash credit है अभी 68 का heading. They change unexplained credit, cash हटा दिया उसमें, वो कह रहे cash is no required, unexplained credit. So section 102 to 107 parallel to 68 to 69D are as it is, almost as it is worded. There are definitely in place of provisos, there are subsections, but the sense of those sections remains the same. And even 115 BB parallel section 195 is there. You can note both these points. Section 68 to 69D parallel 102 to 107 and section 115 BBE parallel 195. Now, I will take this head on, Puri Saab, because I am getting or I have done these cases daily, or what do you say? We get these cases so much. So we are used to with this Jindal Saab, when these sections are applied in a very in a very lackadaisical manner, or a very irresponsible manner, irrational manner, or a mechanical manner. I have a point to make. When I read the new bill, when I read this section 102 to 107 read with 195, I have a point, Puri Saab, it was an occasion to clarify. See, you say that lot of high courts, lot of Supreme Court decisions have come. It is not like this, that you, and it is acknowledged that various court rulings have come, Srivastava Saab, after 1961 Act, and thousands of rulings, gargantuan ruling. So what ruling have come, Khimani ji, for misuse of 68 to 69D? I am just pointing out. For example, they say that regular business transactions should not be covered in 68 to 69D. Are you there? You add
Yes.
same purchases in 68, 69, etc. It was an occasion to clarify it there. That AO could not apply, even if it is satisfied or dissatisfied, as Jindal Sahab was saying. 68 to 69D out not to have been applied to regular business transaction. That is not there. This is. I humbly wish if somebody is listening me, Rajesh bhai, it should have been there. And what is prompting me to say it? Various court rulings have said it across country that regular business transaction, Khewani sahab, should not have come in section 68, 69D or 115 BB nahi lagna chahiye, 115 BB. The reason, because regular business transaction should be assessed on the principle of real income and business income as per business head, not as per 68 to 69D, not as per 115 BB, not as per 102 to 107 and 195. So
Kapil
one
bhai,
point,
आप अभी भी suggestion भेज सकते हो, because the matter is still being discussed.
I'm sending you to suggestion. मेरे लिए तो आप ही बिहारी जी हैं. You are and that's why I'm saying in this humble submission, sir. And you have right. You should see, only you are the people or person, sir, Apuri sir. You can understand my submissions in the humble manner, that why I'm making this, that regular business transactions should never come in 68 to 69D, that is 102 to 107. Second point, that if I have already offered to tax something in the business account, P&L account or income computation, that should not be 68, should not be applied to income already offered to tax. Rajesh bhai, that is point number 2. Because these two things are leading to extreme harassment, and across country courts are deleting these additions. Still, we are fighting for the litigation. And if you have these sections which are being allowed to be used in the manner which courts are regularly frowning, and you are making a grand exercise, and then you are not incorporating those views of the various great judges and jurists, then what is the purpose of, then how the litigation will reduce? That is the question I ask to myself. Are you getting my point, sir?
Yes, we are getting your point.
So these are the 2 points on 68 to 69D. One, regular business transaction, that is not off, that it can be still tax as per the no change. And second, sir, this income already offered to tax. I have a point to make about Srivastava 195 also. 195, that is 115 BB. We have seen, sir, this section 115 BB rate is also wrongly applied in directly in demand notices. And we have seen this highest rate section, Khewani ji, is being allowed to be applied by any officer at his whims and fancies. I would have felt happier. We have every time discussed this 30% to 60% in 115 BB was done by late Jetli Saab when demonetization was announced in 2016. We are in 2025. After 9 years, also 60% rate is as it is. Happy time would have been there. Yes, sir. Sorry.
115 BBE was introduced only due to demonetization.
No. So that was introduced with Puri Saab in 2012. And now it was increased in 2016 from 30% to 60%.
Yes.
Now I am asking a question. It was done for demonetization purpose. Now you are in 2025, and after 9 years, demonetization is not on. And this section, in my humble opinion, should not have been there in the law. But it is there for its own fortune, because it is increasing the tax collection and like that. Sorry, it is easy to apply it, so it is being there with due respect to the lawmaking body. Now, why it is not being made like this? That if you are applying this section, then you are required to have some kind of higher authority sanction. And this is my humble suggestion. If you have to have this section in the law, then make it stringent safeguard, so that high pitch assessments due to 115 BBE can be avoided and litigation can be really reduced. Without 68 to 69D being rationalized, without 115 BBE rationalized, corresponding provision 102 to 107 and 195. So this is point number 2 of my suggestion, Puri Saab. Now, when I was sir,
when you talk about high pitch assessment, can we ask for that? Like earlier, it used to be whole time that if there is an assessment, proposed addition is more than 1 lakh, it will be referred to the joint commissioner.
Absolutely. So it is one of the good points. That is why, Srivastava Saab, when you make changes and when you make healthy changes, then changes allowed for one of the important purposes is reduction in litigation. Merely sentences and keeping the provision in that manner which allows them to be misused and abused, and taxpayers being continuously harassed and going to the doors of Rahulji, the 115 BB parallel section is 195. 195.
So, Kapil bhai, the intention of reducing litigation must show.
And I tell you how, Puri Sahab, it is happening. And Srivastava Sahab and Jindal Sahab, you will all appreciate. There is a ruling of Supreme Court of India. You can note the citation 427 ITR 288 by Justice Sanjay Kishan Kaul in National Cooperative Case. he has been the judge of the Supreme Court. He has written an income tax decision, landmark decision in national cooperative case. Citation, which I recall from my memory, is 4207 ITR 288. And there is a paragraph, last paragraph, Jindal Sahab, which Justice Sanjay Kishan called in this landmark order of Supreme Court. Note down what he says. He says when Soli Sorabji became Attorney General of our country, Palkiwala Sahab wrote a congratulatory letter to Soli Sorabji, and that letter said, advise Mr. Sarabji, Palkiwala Sahab, कि when you fight for government, then your endeavor should be that justice must go to the citizen and not government should win invariably. That should not be the approach. This is quote unquote from Supreme Court decision. Now, if you have to reduce litigation, this approach has to come on the ground level in the statute also. Without minus this, you will not be able to reduce the litigation. That is my humble submission. So where is that thing coming? Now, no accountability, no section 102 to 107 and 195. You know, Srivastava sir, 90% of when the cases are being reopened, what is the idea to reopen, to apply these sections?
And blindly they do
Yes.
it. Blindly they do it.
So unless you sensitize section 68 to 690, that is 102 to 107, read with 195, how the litigation can come down? You know, all of these sections, when we go to courts, ITAT, High Court and Supreme Court, they have said time and again, Khivani, they cannot be applied in mechanical way. You can't, and especially 115BB kind of section is still there. And your third point I want to flag here is regarding this charitable trust, sir. There are a lot of interesting changes on charitable trust, Rajesh bhai. There is an entire new, what do you say, now they have, if I'm allowed to read, if I'm allowed to read from this frequently asked questions in the non-profits organization section, section number 2, they say at present, all of you can note, there are 5 places in which scattering is done of charitable trust, Puri Sahab. One is section 2 clause 15 charitable purpose definition. Second is section 1023C, 11, 12, 12A, 12AA, 12AB, 12AC, 13. I'm repeating. Chapter 3 में 1961 Act में 1023C, section 11, 12, 12A, 12AA, 12AB, 12AC, section 13. Chapter 6A, 80G, chapter 12, 115BBC and 115BBI, that's special rate sections, anonymous donation and specified income. Chapter 12BB, 115 TD, TE and TF accredited income. So Srivastava Sahab, they say at present charitable trust provisions are scattered across the Income Tax Act. So they say, no, we have to make it more rationalized and sensible. So they have made a lot of changes regarding this. Now, what is the important change? Now, the important change is made in this. There is a very interesting definition given. First of all of you can note registered non-profit organization. There is a very interesting definition, registered non-profit organization. Rajesh bhai, my voice is coming. It is in place of trust, Jindal Sahab, a common word there, registered non-profit organization, RNPO. So it is being defined in a comprehensive sense, and they say the present Income Tax Act uses different terms such as trust, institution, university, educational institution in different provisions. The term registered non-profit organization has been defined to mean any person having a valid registration under section 12A, 12AA of Income Tax Act 1961, and such registration has not been cancelled. The use of common term registered non-profit organization intends to avoid confusion and for lucid understanding of the provisions of the bill. So this is a very interesting thing, registered non-profit organization. So you have to call these things. Are you getting my point, sir? So they have clubbed all these changes in a particular place. And I have also made in my, what you say, this tabular. There is a chapter, Rajesh bhai, now. There is a chapter which is specially dealing with this charitable trust, sir. And in that chapter, they have made a very detailed procedure. They have included registration aspect. They have included other aspects. Now, this is chapter 16B. Are you noting, sir? Chapter 16B, 17B, sorry, chapter 17B of new bill 2025 and sections running, Puri Sahab, of the charitable trust from 332 to 355. What is the interesting part of this change? It can, in the bill, Rajesh bhai, they have consolidated the all related provisions of charitable trust registered non-profit organization. The chapter heading, relevant chapter heading in the bill is special provision for registered non-profit organization. What is the chapter heading, Srivastava Sahab? Special provision for registered non-profit organization. That is chapter 17, part B. in the bill 2025. There are 7 segments. 7 segment में क्या क्या है पुरी साहब? पहला registration. First is registration. Second is income of registered non-profit organization. Third is commercial activities by registered non-profit organization. That is 215 proviso wala. Fourth is compliances. Fifth is violations. Sixth is approval for purpose of deduction under 133, and 7 is interpretation. So they have in this what you say frequently asked questions explained that how this chapter 17b looks like. First is registration. In registration, there is application for registration, switching over of regimes. Income, how the income will be computed. Commercial activities में what kind of commercial if you do commercial activity, how your income will be assessed. Compliances में books of account कैसे करना है, audit कैसे होना है, return of income कैसे होना है, permitted mode of investment. Finally, violation अगर आप करते हैं श्रीवास्तव साहब, there is violation, specified violation, and tax on your voice is not coming. Puri साहब, you are saying something. Puri साहब, your voice is not coming.
Puri साहब, unmute
muted है।
yourself.
पुरी साहब
पुरी साहब,
म्यूटेड है, unmute करो।
पुरी साहब कहीं से पैसे ले रहे होंगे, इधर नहीं बात कर रहे।
पुरी साहब, kindly unmute. Your voice is not coming. You are on mute. Rajesh bhai, can you go?
कपिल भाई आप कैरी ऑन करो।
Okay. So the structure of 17b is registration first, second income, third commercial activities, fourth compliances, 5 violation. They have made a this flow chart in question number 26, and they have very interestingly Rajesh bhai said ki how this will work. So ultimately their purpose is to see that non-profit organizations can understand in the terms of law where they stand, and they can have a consolidated reading. Jindal Saab, there is no such change at such, the ground level, there is no such change that plus or minus. It is almost equal. But the framing is different totally. When you read chapter 17b, when you read from the section 332 to 355, then and when you know, sorry, kya keh rahe Rajesh bhai? So when this criminal laws came, and we have Bharatiya Nyaya Sanhita, all these things. So all judges and all policy makers, all this, Kimani Saab, all these are to struggle with at least remembering the section name now. This is very simple thing. As you know, 68 comes into our mind. Srivastav Saab, credit, cash credit. 148, reopening. 144B, faceless assessment. 143, scrutiny assessment. So like this, 132 search and seizure, 133 is survey. Now you have to, that's why I have to do this homework which I give to Srivastav, apna Rajesh bhai, that there is a very interesting comparison of the changes of the chapters names and section names, or what do you say, section numbering and all those things. So you have to definitely go through all this note which I have prepared, 6-7 page note, and there is a table I have framed for 1961 law vis-a-vis 2025 bill. And this idea came to me when I read a book on criminal law, how they have compared. Are you getting my point, Rajesh bhai? Inspired from that, I made this homework in the last 12 hours for all of you. And maybe there is some errata. I humbly apologize. Kindly forgive me if there is any deficiency or any shortcoming. So what I was submitting, Kimani Saab, you want to say something? Please say.
No, I'm listening to you.
Okay.
Signal
sir.
was not coming, so I was mentioning that.
So my voice is coming clearly, sir?
Yes, audio is coming, video is not coming.
मेरे को तो ऑडियो भी दिख रहा है, वीडियो भी दिख रहा है।
ओके है जी, ओके, बिल्कुल ओके है।
ओके ना जिंदल साहब?
चलिए।
हाँ जी,
आपने ओके कर दिया तो ओके हो गया सर, तब तो जलंधर वाला ओके हो गया।
हाँ ठीक है, चलिए।
राधे राधे। तो हम कहाँ थे
जी,
सर? हम
जी।
नॉन प्रॉफिट ऑर्गेनाइजेशन को थोड़ा बहुत समझ पाए कि दैट दिस डेफिनेशन ऑफ रजिस्टर्ड नॉन प्रॉफिट ऑर्गेनाइजेशन, श्रीवास्तव साहब, will have to be understood, and in the time to come. And there is a very interesting definition of in the new law of this word, what you say, registration also. They say that they have defined 2 things in the definition clause, and this is a very interesting definition clause in the income tax bill 2025 section 2. Rajesh bhai, mein kitna definition you want to note? Section 2, now there are 111 definitions. Last definition is of virtual digital assets. Kitna definition hai sir? 111, 111.
ये तो ट्रेल बना दी उन्होंने तो।
इसे ट्रेल नहीं है, वो उनके हिसाब से इजी है कि कोई आदमी अपना रिटर्न खुद भरना चाहे। वो कह रहे हैं वी वांट पीपल, सॉरी आई एम सेइंग लाइक दिस, they want that self compliance increase, not professional help is required. It can sorry, I'm laughing. Is it possible by any means, sir? Huh?
I said they're indirectly helping you to increase litigation.
I am not saying
आदित्य जी
because
कह रहे हैं कि सगुन ऑफ रुपीज 111
always I, Rohit ji, you will have definitely circulars notifications. They have already said in frequently asked question, Agrawal साहब, कि that definitely when this law becomes 2026 के बाद होगा. अभी 2026 तक ज्यादा बेचैन होने का you will need not be anxious and very much, क्योंकि 2026 तक तो आपको 1961 का 1961 लॉ के साथ ही चल रहा है. You have to go with the 1961 Act. So till 2026, that is I have already clarified, Jindal साहब. So we have not to burn our blood or energy too much. Yes, from academic science, it is appreciated that you can definitely, we will all explore that. That's why we are keeping this program, this session, and we will all learn. Last day when I was speaking in this Lakshmi Nagar Study Circle or Vikas Marg, Rajesh Bhai, so this is clear non-profit organization. You can all check for this definition in these sections of and this is a very interesting word, interpretation. They don't use word Srivastav Sahab definition clause. They use the word interpretation. Are you noting it? So provisos or explanations kya, and they define word ko bolta hai, definition clause ko bolta hai wo heading interpretation. Rajesh Bhai, in this finance this income tax bill 2025, there is a very interesting change regarding these exemptions. You know, exemption section 10 is also a very crowded section. And by that time, lot of exemptions, Jindal Saab, there is a very detailed question answer on this point also. That how many exemptions are there? You know, section 10 of the Income Tax Act, what are the difficulties in comprehend? Now, it says, can you briefly explain the provisions relating to exemptions provided in present section 10 of the Income Tax Act? Present section means present section 10 of the Income Tax Act 1961. The provisions relating to exemptions, I am reading from question 3, part 1 of FAQ. The provisions related to exemptions are contained in section 10 of the present Income Tax Act. There are around 140 clauses. Kitna clause hai? 140, Rajesh Bhai. In section 10, providing exemption to different persons and income. Now, Srivastava Sahab, exemption in section 10 sometimes goes with the person and sometimes goes with the income. You all of you know. Sometimes exemption is qua person earning the income and sometimes the income qua income. They say section 10 has 140 clauses. Section 10 evolved in its present change with changes being made in different years, etc. Since section 10 starts with an opening sentence and different exemptions provided in form of clauses and inherent limitations in the drafting. Now they say we have all clubbed them in following schedules. Please note, this is very important discussion, Rajesh Bhai. Schedule 2, Schedule 3, Schedule 4, Schedule 5, Schedule 6, and Schedule 7. In schedule they have taken. Kahan shift kar diya? Section 11 is still there, but section 11 is a small section now, very small section, section 11 of the 2025, not 1961. It is a very small section, and if I'm allowed to take you to that, it says it has 5 subsections, section 11, subsection 1, 2, 3, 4, 5. And first subsection says, in computing the total income of any person for a tax year under this act, any income enumerated in Schedule 2, Schedule 3, Schedule 4, Schedule 5, Schedule 6 shall not be included subject to fulfillment of conditions prescribed therein. So for exemption, you have to refer to which schedule, Srivastava Sahab? Schedule number 2, Schedule number 3, Schedule number 4, Schedule number 5, Schedule number 6, Schedule number 7. अब इसमें important कौन सा है राजेश भाई, वो नोट कर लें. Schedule number 2, income such as agricultural income. Are you noting? Schedule 2. Schedule 3, certain eligible person for exemption, partner from HUF. And Schedule 7, persons exempt from tax. So I have noted somewhere, sir. In this table, you will find very interesting, Rajesh Bhai, how many rows are there. I noted Schedule 2, 3, 4, 5, how many rows? Schedule 2 में row है, जैसे कितनी rows items है. Schedule 2 has 16 rows, agriculture income. Schedule 3 has 39 rows, that partnership from HUF. Schedule this 7, important schedule, 48 rows. So you have to read the table and schedule, and in that you have to find out whether this person or this income is exempted from tax or not. Read with section 11 subsection. Are you there, sir? So this has also reduced a lot of words. Non-profit section has reduced a lot of words. Exemption section has reduced a lot of words. And third change, Puri Saab, they say that three radical changes in the drafting. One regarding non-profit organizations. Point number 1, you can also navigate, Jindal Saab, आप लोग पढ़ सकते हैं. NPO का जो change है, they say lot of words they have given in the last question. कि सबसे ज़्यादा तीन जगह, three areas they flagged. कि 3 areas में changes की वजह से सबसे ज़्यादा reduction हुआ है words का. And that I can tell you can note exemption related provision, TDS, TCS, and non-profit organization, Rajesh bhai. Exemption related provision, Income Tax Act used 30,000 words. Now word is 13,500. Reduction by sole 16,500. In exemption related, 30,000 words were used earlier. Now 13,500. 16,000 has reduced. NPO 12,800. Now 7,600. 5,200 reduced. TDS, TCS. Now what they have done, TDS, TCS also, they have made a table and formula, Rajesh bhai. Instead of having sections, they have made it compact. They have used tables, they have used formulas, and then they have specified TDS for residents, TDS for non-residents, and other TDS. Jindal sir, this is the framing of TDS. So in that, now I found a very interesting change, Puri Sahib here. Puri Sahib, you can open your mic. Now what they do, they say now we have excluded this provisos and explanation. I find Srivastava a very interesting change. They have put in all these tables various notes. You know, notes. Without that note, you can't understand the table. You know, when we file income tax form, there are some notes to that. I don't know. Now I'm not filing it. You can tell me. Hota nahi hota, Rajesh bhai, there are notes to forms.
बिल्कुल होते हैं, बिल्कुल होते हैं.
So all these tables have statutory notes. Now these are statutory tables, part of the statute, that bill, and that has notes. So to understand the table, you have to understand the notes, and notes are to be read along with the table and the law. So for me, I was reading a table. So it's not that easy to understand a table with notes.
For a layman, it is very easy, sir. उनकी intention ही ये है.
No. If you say proviso explanation as a note, Jindal sahab, I just say on a lighter side. Can you say it is improvising? No, if you say something as no, proviso nahi hai wo irrespective word aa gaya, notwithstanding ki jagah. What it does? What is this? Irrespective phrase is replacing notwithstanding. Good.
But मतलब तो वही है, मतलब तो वही है.
नहीं. For to understand, आपको जितना one has to make efforts to understand a legal symmetry out of it, legal sense out of it. You have to invest that much energy and effort. So Saraswat sahab, I want to say this, that ठीक है, tables and this notes is giving us modernized look. But having said that modernized look, people who are going to understand it and implement it, it is the test of taxpayer and tax consultant as it will be the test of tax administrator, with all due respect and humility at my command. So Rajesh bhai, so 3 radical changes: non-profit organization, tax deduction at source, and TCS. There is no they say that we have incorporated, and I believe that is right, Finance Bill 2025 tak, whatever changes is incorporated in this. That is what Purisa we were wondering last time. So 3 important changes: NPO, non-profit organization, TDS, TCS, and exemption. Now some friend was asking.
2030, this should also settle down. हम लोगों को भी याद रहने शुरू हो जाएंगे sections. We will also know how to interpret what. तो 4-5 साल तो सबको लगेंगे.
No, Chhabariya sir पूछ रहे हैं TDS, TCS sir. See, whatever TDS, TCS you have to do right away, sir. Abhi 1st April 2026. Please don't trouble your energy on this. When this law will be on and this is enacted Parliament, we have till the time lot of discussion sessions to happen, and you will all learn, and I will also learn. We will all get enlightened by the time this Srivastava sir becomes an enacted law, and by the time it is made operational, then you will have lot of what you say masala and things to be helping hand. So 148. Now comes my favorite section, another favorite section, 148. I was reading this, sir, this chapter. Kindly note, what is the chapter of procedure for assessment in the new bill 2025? Sorry, sir, my throat is still very bad. This is chapter 16. You can all note chapter 16, sir. Chapter 16 and reopening related provisions, including reopening related provisions, section 279 to 284. Please note, section 279 to 284 are the reopening provisions, Puri Sahab, in the Income Tax Bill 2020. When this law came to my hands, I can say I said 68, saw first Puri Srivastava from a bad habit, and saw 148 section corresponding. So I found one Kiwani Sahab tweaking. I found it's a tweaking, but later on I realized, no, it's 4 year and 6 year time they have done. now there is 3 year and 5 year, but it is co-assessment year, na? Now 4 and 6 year co-tax year. Are you getting it is same?
Yes.
Is it clear, sir? In the new bill, in the new income tax bill, the section which is dealing with the limitation provision has 4 year and 6 year limitation, Rajesh bhai. People say it is increasing. I also thought it is increasing 1 year. No, it is
My
not increasing.
correction
It
is
is same
not
because it
stable.
is now with the vis-a-vis tax year instead of being vis-a-vis
Assessment
assessment year. Are you there? Yes, sir. So old wine in the new bottle or new bottle, new wine with the new wine, etc., everything you can say, sir. You know, there can be various phrases and catch phrases for this kind of changes, but it is very interesting. They kept 148 same. Yes, for information suggesting escapement of income criteria, that is same. Before 148, they will do 148 capital A kind of an exercise, that is same. They will take sanction of higher authority, that is same. I was telling you, sir, two suggestions I told. Suggestion number 3, Puri Saab, suggestion number 3, and you would love to hear it. And it's a very, very important suggestion, Rajesh bhai. You know, in this law of income tax, 1961 Act and 2025 bill, I'm saying with responsibility and very, very important thing. We have all faced and facing enormous problem to get these sanctions and approvals from the department, which they believed is a national secret. And they are not ready to share with the assessee at all because they believe it is like something which is secret, a national secret, or it is to be not given to the assessee even after begging and prostrating, enormous begging and calling it. I thought, Srivastav Saab, if you have to make the law less litigation wise, then you have to have the untransparent wise. You can note my point. All these sanctions and approvals wherever required are to be supplied along with the copy of the notice and order. There should be a particular statutory mandate for this. If these sanctions have to be given some meaningful sense, Rajesh bhai, without this statutory prescription, I'm sorry, nothing is compelling them. You see them, they don't give sanction, they don't provide approvals, they keep them in ghungat and this kind of undercover, as if it is a national secret. Courts, Bombay High Court has said. And why not, when High Courts have said, Srivastav Saab, Bombay High Court, our Supreme Court decision, which I argued, this Delhi High Court, Tia Enterprises, Puri Saab, 468 ITR, page 5, you can note, and 468 ITR, page 10, Delhi High Court and Supreme Court, 468 ITR, page 5, and 468 ITR, page 10, Supreme Court, that sanction copy has to be supplied along with the reasons. And Goodwala and Sons, 462 ITR 33. So why not this sanction? They are healthily incorporating the Supreme Court wisdom into the law. New law, when it is going to be the new law. Puri Saab, your voice is not coming. You want to say something, sir?
Puri Saab kuch nahi keh rahe.
So the sanction has to be supplied with the copy of the reasons or the order or the notice, sir. This is to make compulsory. And fourth point, Rajesh bhai, you know, I was reading this entire search section. Srivastav sir, search and survey are told to be the very important. Sir, Khimani Saab is raising hand. Rajesh bhai, unko enter kar le. Search and seizure. So what is the corresponding search section, sir? Rajesh bhai, you can note the corresponding search section in the new income tax bill, sir. That is search and seizure section 247. कौन सा section है राजेश भाई? 132 is the income tax act and this 1961 का है 132 और income tax bill का है श्रीवास्तव साहब 247. Now this 247 section का content is same, Jindal साहब, that search and seizure raid can happen in the same section. But I have a point to make out. There is a section which is being which provision is there in the income tax act also, 249. Rajesh bhai, note this section 249. What this 249 says, I will read for benefit of all the 400 participants. What this 249 says. This is not the way the litigation can come down and the confidence of the taxpayer can increase. You will be with me. You can read section 249, what it says. It says, sir, the reason to believe or reason to suspect as referred to in section 247 or 288 recorded by the income tax authority shall not be disclosed to any person, authority or appellate tribunal. This was an explanation in 132 which has been taken now in 249. It says, Jindal Saab, ki such reasons will not be disclosed, Puri Saab, to any person, authority or the tribunal. I have a serious humble reservation on this kind of confidentiality clause and secrecy clause. When you have open governance, when you have good governance, when you have democratic governance, when you have constitutional governance, is this kind of keeping a search person in immense, endless mystery that why search has happened is good, is right, is correct. What am I there, sir?
कपिल भाई, सबसे बड़ी डिफिकल्टी पता है क्या है कि ये कहते कुछ और है, करते कुछ और है.
Why not this 249 section is not, why it is there? I am asking a question, Srivastava sir. What is the problem to give the reasons of the search after search has completed and assessment has started? What is the problem? What will happen after you have done the search and you have made a person hell lot of things with him, and you want to see that this person, gentleman, unless expand and hire Kapil Goel like kind of a lawyer to go to the raid, and then raid court gets in sealed envelope this kind of search kind of action satisfaction, is it right?
And it will not be divulged to any tribunal also.
This kind of provisions, my humble suggestion, 249 parallel to explanation to 132 should not have been there, sir. And one thing, Srivastava sir, you can open your mic. You want to say something, please. Your mic is mute, sir.
You see, Kapil, on not providing the reason, I see another issue in this. What happens many a times, while there is a search, you obtain an authorization in respect of somebody else. Whereas if you go for approval from somebody, like it is generally blindly given on the recommendation of the search party. Yes, go and go there also, without the approving authority actually being aware of what is the ground reality. So, and they do not want, they don't want to put any fetters
So there
on
should
them.
be some sort of, Rajesh bhai, transparency. Anyhow, let me take another point of this search provision, sir.
अगर अनिल जी एक चीज बताइए ना, कपिल भाई का ये इशू है कि सर्च हो गई, उसके बाद तो बताओ भैया क्यों हुई थी.
उसके बाद तो देना चाहिए. There is no justification of not giving it.
क्योंकि आपके यहाँ पॉलिटिकल सर्च और रॉन्ग सर्च होती है, सर. हमारे यहाँ, सॉरी, विद ड्यू रिस्पेक्ट.
Yes, बिल्कुल होती है.
कपिल गोयल नहीं बोल रहा है. जजमेंट्स विल से दैट द सर्च आर हैपेंड फॉर अदर पर्पस अदर देन द लॉ.
वो तो आजकल लोग इतना चला ही रहे हैं कि भाई ठीक है, ईडी और जो आप अथॉरिटीज को यूज कर रहे हैं.
Now, there is a very interesting thing. I was reading this section corresponding to in this 247 में ये subsection 132(4) statement होता है. That statement is a very big basis to, मतलब assessee को when search happens तो उसको dominate करने के लिए, राजेश भाई, statement 132(4) बयान, statement of 132(4) search, it is a very serious thing. Now I was thinking, Puri Sahab, there can be some important change that statement will not be recorded unless some incriminating material is there. So what is your take on this point? The statement 132(4) recording and even in the new law 247 same. I have a humble question or submission. If you have seen the litigation in the income tax law on the search cases, one of the primary reason is the confessions and surrenders being forcefully taken, coercion and undue influence in the search statement. Because when search happens, Puri Sahab, you will appreciate the assessee who is searched is in the domination and the department dominates. So unless and until you have a clause, Rajesh bhai, in the section of the search that no surrender and extraction will be taken.
अगर कपिल भाई एक चीज है ना,
why not? See, I'm taking for myself now. I have a lot of cases which I daily go to the court, where courts and High Court and Supreme Court India has said कि no statement and CBDT himself has said in circular. Why that thing is not coming, Srivastava sahab, in the law? That statement will not be recorded unless and until corresponding independent corroborative material is there.
And the purpose is to confront with the material कि भैया इसके बारे में तुमको क्या कहना है.
So first thing is this keeping the reasons of the search secret and confidential. Second is this statement of 132(4) that is parallel in 247 same. And third aspect, Puri Sahab, with due respect, is this. I am saying with all due respect to the practitioners who are practicing in the search cases, maybe they find appraisal report to be a healthy document, but I find it's the most naughty document, notorious document, sir.
I agree.
Appraisal report in the income tax litigation is the root cause, Tarunji, of thousands of litigation. And how this appraisal report by investigation wing, an informal document, is made and is the cause of litigation is to be seriously considered when you are going into the 2025 historic new legislation. I wish that appraisal report should be sensitized. It should be regulated. It should be controlled. That such appraisal report should not become a law in itself.
और फिर क्या उसके ऊपर कोई अपनी इंडिपेंडेंट इंक्वायरी नहीं करता है?
And in these three things, statement, search reasons, and appraisal report, no positive change in the bill of 2025, sir. Next aspect, when I looked, Srivastava, of this entire law, when we see the litigation going like this, that Bombay High Court has Chamber of Tax Consultant has to file a PIL for this purpose of 87A, utility is not giving benefit of rebate of 87A. And Chamber has to file a PIL, and Bombay High Court Justice Sonak has to write a 60-70 page order reminding government of its constitutional duty towards taxpayers of this country, that Article 265 and Article 300 capital A of the Holy Constitution of India are to govern the tax regime. Article 265 and Article 300A. Puri Sahab, there is nothing of this sort being brought in the legislation, that if an assessee is software and utility will not prevail over the law. They should have put in the law now. What is the problem? When Supreme Court of India Justice P.S. Narasimhan in Sunil Bhagat case just few months ago has said CBDT, please clarify that law will prevail and not utility and software and portal.
कपिल भाई, अगर आपकी डिमांड निकलती है, आपका बैंक अटैच कर लेते, उन्होंने पैसे देने हैं, तो कोई बात ही नहीं सुनता वहां। उसके ऊपर भी कोई मैकेनिज्म होना चाहिए ना। They should be officer.
Anyhow, sir, my humble submission is this interplay of Rajesh Bhai, technology versus law, there is nothing in the law. Rather, what they have now, when you read the definition of the word books of accounts, you will find a very interesting definition of the word books of account. Anyhow, Srivastava sir, from chartered accountant angle, people were feeling that audit is going to anybody else. No, section 515 is the authorized representative section. In the definition of accountant, CA is still only there. No other professional is there. You can note it, 515 authorized representative section. Chartered accountant is the only person competent to do the audit. Am I there, Puri sir?
Well,
on this aspect. So there is nothing like that this our auditing area is taken by somebody else.
पहले क्या था ना, cost accountant को भी दे देंगे और को.
And faceless assessment etc. will remain the same. Updated return, regular return, belated return. Rajesh bhai, they have clarified that is same. You are noting, sir? And old tax regime and new tax regime will go in the new bill also. Are you noting? Old tax regime, and this is an important clarification. Some people ask Mr. Goel, in the new bill, old tax regime and new tax regime can go together. Yes. Answer is yes. Yes, yes, yes. So, and they have clarified.
Deductions हटा देंगे.
No, no, no.
Section
they have said grandfathering has been done, Purisa, proper. They say the old deductions will be carried forward. If they are entitled, the period of the deduction will be allowed to be completed.
Okay.
I believe they should behave in gentleman manner in that manner.
सर उसके सारे जो सेक्शंस थे वो भी इनकॉर्पोरेटेड है इसमें.
हाँ, देखिए मैं आपको बताता हूँ तरुण भाई, you can note it down. I can tell you. I have marked somewhere. Sorry. This is a very interesting, important point, because I was also thinking कि कहीं वो हट तो नहीं गया. There is a question answer where there is a question answer in the frequently asked question. Question 9 part 1. It says, what are the major snapshots of simplification with reference to chapter 6A, that is deduction section? They say the provision of section 80IA, 80IB, 80IAB, 80IBA of the Income Tax Act would still be applicable for the undertakings or enterprises or projects which were already eligible to avail deduction as per these sections, which is ensured by incorporating necessary savings and repeal clause. Is it clear, sir?
नहीं, नए एक्ट में लाए कि नहीं ये क्लॉजेस?
हाँ सर, लिखा है, रिपील क्लॉज है ना उसमें, सेक्शन 536 में.
जब तक ये एप्लीकेबल है तब तक आएंगे.
बट वो न्यू लॉ में कैरी ओवर हो जाएंगे पूरी साहब.
अच्छा, हो जाएंगे.
हाँ जी, देयर इज ए 536 में है, 536 में है, सब सेक्शन 2 में. 536 इज ए, मैंने बताया ना आपको, इट्स ए वेरी वाइडली रिटन सेक्शन. जब नया अलाउ आ जाएगा हम उस पर एनर्जी ज्यादा तब लगाएंगे, पर वो बहुत डिटेल सेक्शन है उसका. रिपील और सेविंग को एक एक वर्ड को पढ़ना पड़ेगा बत्रा जी ढंग से, बट वो ज्यादा एनर्जी तो तभी लगाएंगे ना जब हम 1/4/26 के बाद होंगे. सर मिस्टर प्रदीप गोयल जी न्यू सर, वो गोयल साहब मेरे जो नोट में मैंने जो सर्कुलेट करेंगे राजेश भाई, मेरे से कृपा करके सर थोड़ा कोशिश करें. ये राजेश भाई को मैं ऑलरेडी भेज चुका हूँ टेबुलर नोट. बाकी वो सेक्शन है सर पूरी साहब
शेयर कर लिया उन्होंने.
हाँ वो कर दिए, मैंने बनाकर भी भेज दिया सर. अपना होमवर्क मैं बिना करे नहीं आता अपने इस चैनल के ऊपर. ये चैनल मेरे दिल को इतना प्रिय राजेश भाई, मुझे याद आता है एक भजन और एक भगवान की चौपाई और परमात्मा का नाम कि यू नो कि मैं जानू निज नाथ सुभाऊं, मैं जानू निज नाथ सुभाऊं, अपराधी पर काहू ना काहू. श्रीवास्तव साहब इसका क्या मतलब है समझ में आया? भरत जी कह रहे राम जी के लिए कि मैं अपने नाथ का स्वभाव जानता हूं, वो कभी भी अपने भक्तों पर यू से, इसको इंग्लिश में बात करें तो भरत जी सेइंग टू लॉर्ड राम कि दैट our God is so merciful that he never gets angry and displeased with his Bhagat like Bharat and all of us. So there was one more Rajesh Bhai bhajan lines I was just reciting in my mind, that if we have to call the God, we have to have the feeling, strong feeling of like Arjun. You know, when Arjun was, or Pandavas in the Mahabharata was, so why so they were so near to Lord Krishna? ये पूछा किसी ने कि परमात्मा का, कृष्ण भगवान का, लॉर्ड कृष्णा का इतना सारा आशीर्वाद पांडव को क्यों मिला? क्योंकि जो उनका श्रीवास्तव साहब लॉर्ड कृष्णा के प्रति, ठाकुर जी के प्रति जो उनका भावना था वो बिल्कुल अलग ही था भाव। वो कह रहे हैं हम कुछ नहीं है, सब कुछ जो कुछ है परमात्मा ही है।
complete dedication.
ना कुछ किया ना कर सकूं, ना कुछ करने योग्य, जो कुछ किया प्रभु आपने, आप ही करने योग्य। Anyhow, so I was just winding up. I made some more suggestions you can all note. One is regarding this real income, that Income Tax Act should be, there should be a specific provision in the law that real income should be taxed. But they never bring this kind of provision because they are afraid if real income will be taxed, then maybe they may not be able to make high pitch assessments and create Srivastava sahab, illegal demands to be fought till IT-80. So real income concept, you know, 46 ITR 144 Rajesh Bhai, until this time, various Supreme Court rulings, why not they bring real income? I don't know why. What is the problem to them? What is the problem?
Litigation कैसे कम होगी?
So फिर why they are saying that we want to reduce litigation? With due respect, I'm sorry speaking in this tone.
तखनी और ये फर्क है.
Shivani ji, why they don't want to bring real income concept in the legislation?
कपिल भाई आपका ख्याल रखा है उन्होंने,
present
अगर लिटिगेशन कम होगी आपका ध्यान कैसे रखेंगे?
हम आपको पता है, मैं बताता हूँ मेरा क्या होगा आपको। मेरे को पता था ऐसा कोई दोस्त मिलेगा तो मैं उसको जरूर ये सुनाऊंगा। उसके लिए क्या हुआ, एक कुंभन दास ऋषि रहे भगवान कृष्ण के सर। यू नो, कुंभन दास जी एक ऋषि रहे। उन्होंने क्या कहा, जब वो भगवान के ऐसे भक्त थे राजेश भाई, और अपने इधर साइड के थे, ब्रिज साइड के धर्मेंद्र जी, तो उनके पास कुछ भी साधन नहीं थे, और वो परमात्मा के ऐसे भक्त थे। लॉर्ड कृष्णा यूज्ड टू सिट विद हिम, भगवान उनके साथ बैठते थे। एक राजा को जब पता चला कि मेरे राज्य में एक ऐसा व्यक्ति है और ऐसे ऋषि हैं जो इतने बड़े हैं और उनको मैं आशीर्वाद लेने जाता हूँ, वो उनके पास गए, उनसे बोला कि मैं मुनि जी आपके लिए क्या कर सकता हूँ। 2-3 बार तो उन्होंने उत्तर नहीं दिया राजेश भाई। दोबारा कहा, जब पूछा तो कहा दोबारा मत आना। ये आपके लिए भी कह रहा हूं, अपने लिए भी कह रहा हूं। कुंभन दास कोई मिलेंगे ठाकुर जी, और नामदेव और मीरा ने क्या कहा, ऐसे ही नहीं है जो भगवान के भक्त हुए हैं उन्होंने संसारिक साधनों को तो पकड़ लिया कि कपिल को पैसे कमाए और फीस मिले, और उसके लिए वो गलत बात को भी सही कहने लग जाए और कहे कि नहीं मुझे पैसे किसी तरीके से मिल जाए बस, और मैं भगवान कृष्ण के उन वचनों को बिल्कुल दुरुस्त कर दूं कि जो कहता है सारथी बनिए स्वार्थी मत बनिए। वो बेकार बात कही है उन्होंने। क्या हैज ही सेड फॉर हिज काइंड ऑफ, क्या वो भगवान कृष्ण को मानते क्या है फिर, अगर हम सारथी भाव ही नहीं समझ पा रहे हैं? अगर मुझे इस बात के लिए किसी बात को गलत सही कहना है कि मेरा काम कैसे बढ़ेगा, भाई साहब मैं भूखा नहीं मरूंगा जब तक बिहारी जी की दया मेरे पे रहेगी। दुर्योधन ने अपनी एडी का जोर लगा लिया उस युद्ध को जीतने के लिए, पर जहां वो कहता था करण इतना बड़ा युद्ध था कि जब भगवान कृष्ण सामने थे सारथी के रूप में और हंसते थे तो मेरी एनर्जी कम हो जाती थी। ये मैं नहीं कह रहा हूं, संत कह रहे हैं, ये मैंने वहीं से कॉपी करा बात। तो आपको बात हम्बली कह रहा हूं मेरे बड़े भाइयों, ऐसा नहीं है सर, सारथी भाव रखना चाहिए हमको, स्वार्थी भाव नहीं रखना चाहिए। तो यही भावना है सर। एनी हाउ राजेश भाई, ये वाला बिल पूरी साहब थोड़ा बहुत जितना मैं डिस्कस कर पाया, बाकी इसकी अगली मीटिंग होगी। अभी हमारा 7:20 हो गया, मेरे को आधा घंटा जो न्यू इनकम जो जजमेंट्स आए कुछ, इफ यू परमिट मी श्रीवास्तव साहब, आई कैन डेफिनेटली। और वो जो 148 वाला चेंज आशु भाई आप बोल रहे हो, नो साहब जो भी आप ये क्वेश्चन पूछ रहे हो ना, न्यूली रिस्पेक्टेड 100% एक्सपोर्ट ओरिएंटेड अंडरटेकिंग, आई हैव ऑलरेडी टोल्ड यू, they have very categorically stated in the frequently asked question, nothing has been minused as far as the exemption which were earlier available is concerned. They remain on the statute board as it is. Are you with me sir on this राजेश भाई? पुरी साहब कुछ उन्होंने उसको सब्सट्रैक्ट नहीं किया है। Anyhow, I am just discussing, kindly permit me sir to discuss some landmark decisions of the Supreme Court which have just come. 5-6 rulings Puri sahab I will take, and although there are a lot of rulings but I don't know how much I am able to cover.
देखला आपने शेयर भी किए हैं शायद।
सर कुछ तो मैंने करी हैं, बट एक आध तो मैं जरूर आई एम डेफिनेटली गोइंग टू डिस्कस समथिंग व्हिच इज एक्स्ट्रा ऑर्डिनरीली इंपॉर्टेंट सर, बिकॉज there has been some very landmark important judgments, and since a lot of people are also there, let me just so there has been two rulings of Justice Rishikesh Roy of Honorable Supreme Court. I am just telling you by the name of the judge. You can note the name of the ruling. First ruling which I am discussing here is, sir, this is Independent Sugar Corporation Limited versus Girish Shriram Juneja. I can share the screen if it is possible. Is it coming on the screen, sir?
बिल्कुल आ रहा है
Yes, sir.
सर.
Yes, sir.
Now, this is a landmark ruling of Justice Rishikesh Roy, Rajesh Bhai. Why I am saying so, Puri Saab? In this ruling, there was an issue regarding interplay of this insolvency bankruptcy law and some procedural safeguard in the law. And the procedural safeguards in the law regarding this natural justice, show cause notice and approval being taken. You know, many times we have seen department treats procedural safeguard ki wo aise hi hai. And I'm telling you, this paragraph you all note. ये देखिए सर, दिस इज द पैराग्राफ नंबर 152, द अपशॉ पैराग्राफ नंबर सॉरी paragraph 152, the indispensability of the procedural safeguards as an integral component of a just legal order must be given its due weight, especially as the procedural requirements are not mere formalities. Am I there, sir? My voice is coming?
बिल्कुल
Yes,
बिल्कुल.
yes, yes.
Are not mere formalities to be circumvented for expediency, but substantive protections designed to ensure fairness and transparency. Why this line is landmark? I'm saying, Police Sahab, all Srivastava procedural safeguards in any statute have to be strictly fulfilled, like show cause notice, like natural justice, like sanction, anything, any law. And in that light, the procedural lapses with regard to the objections of the proposed combination and consequent devastator modification proposed within the framework of Competition Act seriously vitiated the integrity of the process. It is therefore reiterated and reinforced. This line is landmark line, I believe. It is therefore reiterated and reinforced that adherence to procedural propriety is non-negotiable and ends cannot justify the means. क्या मतलब वो पुरी साहब कि if you are making an assessment on a tax evader, you say we are assessing, then you can't be allowed to keep procedural safeguard on bay. And secondly, in this order, there is a landmark observation. There was an approval which was a conditional approval. You know, approval cannot be a conditional approval. The Supreme Court in this judgment, Justice Rishikesh Roy has very beautifully analyzed. You can note it. That practical challenges, and he has said that all conditional, if you have an approval in the law, and that approval is a conditional approval, Khimani ji, that it is given to subject to some condition, then it is no approval in the eyes of the law. This is a first kind of Supreme Court ruling on that point. So I believe this should go a long way as far as procedural safeguard point is concerned and conditional approval point is concerned.
रेशियो इसका बहुत इफेक्टिव है.
That is why, sir, I have kept it for you, sir. It's you know, when I am bringing something for this particular forum to discuss something. Now I am bringing another. Let me bring this another what you say judgment. This is. Sir, is it coming?
बिल्कुल. कृष्णदत्त अवस्थी.
Now kindly see in this judgment of Krishna Avasti, I can just tell you why this is a landmark judgment. Krishna Dutt Avasti versus State of MP. There was two judges who have a dissenting opinion. One Justice Vishwanath Saab and this Vishwanath Saab. There it is written. You can note this paragraph. You will understand what is the importance of the judgment. Justice J.K. Maheshwari upheld the finding to set aside the selection of Shiksha Karmis on account of violation of first limb of principal justice. Justice Keshi Vishwanath has, however, upheld the selection, citing inter alia breach of right of fair hearing. Therefore, in this case, we are confronted with conflict of opinion, conflict between two fundamental principles of natural justice, that is rule against bias and right to a fair hearing. Now, in this judgment, the Supreme Court of India, speaking through Justice Rishikesh Roy and three-judge bench, has said that when you have a requirement of audio alteram partem, when you have a requirement of fair hearing, when you have a requirement of notice, and there is nothing, then entire proceedings will go haywire, sir. Sir, Ashu ji, I am not Sachin Tendulkar, I am nothing. I said you ना, हमारा औकात या हमारा, मैं अपने लिए बोल रहा हूँ, मेरे को वही संत के वचन याद आते हैं, हम किसी भी योग्य नहीं, हम सब सब्जेक्ट में फेल हैं। ये आपका आशीर्वाद है, प्रभु का आशीर्वाद है मेरे पर। Now point is,
तेंदुलकर मत कहो, ये रिटायर नहीं होने वाले, वो तो रिटायर हो गया।
नहीं, sir, sorry. But I'm saying why this judgment of Rishikesh Roy Saab and 3-judge bench is important. And what was the dissent? Vishwanath Saab said natural justice violation, fair hearing violation will vitiate the proceedings. And Maheshwari Saab said, Judge Saab, Supreme Court judge, no, it will not. So Srivastava Saab, this is a landmark ruling where entire 360-degree view has been given by Justice Rishikesh Roy when you have no notice of a hearing. We daily see in income tax assessments, income tax appellate proceedings, and income tax writs that they are tax rates. This kind of violation of principle of natural justice, there is a argument, what is the prejudice being caused? Argument of prejudice is rejected in this case by Supreme Court 3-judge bench. When there is total violation of natural justice, when there is no notice at all, when there is no hearing at all, then entire proceedings will be nullity. So this is also a landmark ruling of Justice Rishikesh Roy, Puri Saab.
आपने कपिल भाई जस्टिस चंद्रचूड़ का बताया था, जिसने 83 लाइंस का सिर्फ प्रिंसिपल नेचुरल जस्टिस के ऊपर दिया था कि
तो मध्यमम, you are rightly recalling Madhyamam broadcasting was there. It said कि principle of natural justice are constitutionalized in Article 14 and they cannot be violated and they are non-negotiable.
हाँ, they are non-negotiable. वो बहुत बड़ी.
So though they are taken care of in these two judgments, sir. Both judgments of Rishikesh Roy, that earlier IBC law and this other service law judgment, maybe they are in service law and other law, but principle of them fully applies to income tax law also.
The ratio is effective.
The ratio is effective, sir. So now I am taking third decision of Justice Dipankar Datta, which has also just come, sir. And maybe if I am allowed to share the screen of the judgment, and it is there, sir. Is it there, sir?
Yes.
This is there. Bhupinder Singh Gill versus State of Punjab. Now this is the judgment by Justice Dipankar Datta Saab. And what Mr. Puri Saab was saying, this paragraph very succinctly, I will directly come to natural justice aspect. These three rulings which I have just discussed are natural justice. Let me. Sir, this is that paragraph 35. I'm sorry. Now, in this paragraph, Puri Saab, you can read it. Also needs to be emphasized that although the traditional concept of natural justice comprises of two rules that prohibit anyone from being condemned unheard, Menka Gandhi and Madhyamam broadcasting was the decision, Puri Saab, jisko aap bol rahe the. So the Supreme Court says both these rulings are to be guided. And in this case, what happened? There was a reply by a particular person against the disciplinary proceedings. And Khivani Saab, what do you know what they did? They just copied, pasted the reply and dismissed that it is not agreeable. Kindly read paragraph 36. This is one of the landmark finding by Supreme Court. If you are making any order and simply rejecting the reply and without passing a speaking order, then it is also a violation of Supreme Court, says natural justice, and entire proceedings will be vitiated. Paragraph 36. Though the rules closely associated with the traditional concept of natural justice may not have been breached in this case, the contention of the appellate that procedure of decision-making process stands vitiated for lack of procedural fairness has to be examined. So Supreme Court says this is procedurally affected because reply of the cess is not properly dealt with. So according to me, this judgment of Supreme Court is also a landmark order. Now, fourth ruling of the day is, sir, again by Justice Dipankar Datta, and it is of last day, I believe. And in this ruling, Justice Dipankar Datta has discussed a very important concept, and I'm telling you, sir, with my heart, this ruling is going to also be having lot of implication. Now, first note the name of this ruling, sir. Dr. Amara Gowda Patil versus Union of India. And Puri Saab, tell how this ruling is. Dr. Amar Gowda Patil versus Union of India, 2025, INSC 2201, neutral citation. Now, this is on effect of malice. Malice, there is a concept in the civil law, malice, when you act for a purpose which is not allowed by the statute, there is a concept called as malice in law. When malice in law will take place, and when I am specially talking about income tax assessment, reopening, and income tax authorities action and tax authorities action, keeping in mind. Kindly read paragraph 52 for me, sir. 52. Having said that, there is one other aspect which needs to be briefly dealt with. The division bench observed that unless Malafites are proved, the court should adopt a hands-off approach. Broadly speaking, that there could be a little quarrel with such proposition. However, bearing in mind and the fact and circumstances, we hold that division bench of the High Court grossly erred in failing to consider that malafide in the sense of malice, in fact, is not the only condition for interference. It is open to a court to interfere where legal malice or malice in law is demonstrated to exist. What is legal malice? Shivani sir, what is legal malice?
No.
Note it down. Note this word first and then see
Yes,
what.
I'm doing. Noted
This
it
is,
down.
I'm telling you, this is a landmark order which they have cited. In this, please note this citation. This, what is this? Savan Singh Chand versus, I'm sorry, this is something is coming here. Just a moment. Savan Singh Chand versus Punjab State Electricity Board. This, the Supreme Court held that non-compliance of the state own direction would constitute malice in law. Now, this judgment is cited by Pankaj Datta Sahab in last day's order to say that if there is a circular or instruction or guideline of a particular department and that is being violated and then an action is taken, it will constitute as a malice in law. And nothing more is required to be proved. This is what Supreme Court is saying. Now, kindly read this. Non-compliance, sorry. Non-compliance, and it can be applied in income tax thousands of cases. Like CBT instruction and circular being violated, didn't point, that judicial point, you know, Puri Sahab, sanction, CBT guidelines, sanction supply point. So, kindly read, based on the above, there is a little doubt that the state, here the Union of India, has exercised a power for a purpose which is foreign to that for which the power is the lies intended. Viewed from this perspective, the act of appointing the third respondent as chairman, despite he not having the, suffers from malice in law. So, Shivani ji, this concept of malice in law, I never understood better than Justice Dipankar Datta has stated in. And this can have very serious implication in the income tax assessments or income tax proceedings or tax proceedings.
It's like Den ka circular, if not followed.
Thousands of
Well, I
circular
just give
instructions
an
which are
example.
favorable to the when they are violated, department says it is irregularity, Srivastava Sahab. Then it says, no, it should be pardoned and condoned. So Supreme Court says it is a malice in law.
सर कपिल अगर इस जजमेंट को देखें कि 99% डिसीजंस आर मैलिस इन लॉ लीगल मैलिस है
मैंने नहीं बनाया वो डिसीजन मैं प्लीज गुस्ताखी माफ करिए दिस जजमेंट ऑफ सुप्रीम कोर्ट इज एज इट इज वर्बिटिम इप्सिसियम वर्बा जो सुप्रीम कोर्ट की वेबसाइट पे उपलब्ध है
बट दिस एक्चुअली बिकॉज दे डोंट लिसन टू यू सर्कल को ध्यान नहीं देते बोर्ड के अपने इंस्ट्रक्शन को नहीं देखते जो आशीष अग्रवाल के बाद भी हुआ सारे केस उन्होंने उसके
five decisions I have told you of the Supreme Court. Now I am taking 5 decisions of Delhi High Court, 6 decisions Srivastava Sahab on 148. My favorite. Now please I start with the decision of Honorable Delhi High Court where 300 more than 300 petitions have been disposed in the landmark ruling by Delhi High Court Justice Yeshwant Verma Sahab in case of Kanwaljit Kaur on 4th February 2025. So what is Kanwaljit Kaur? This is Aadhaar batch versus income tax officer.
Right.
Kanwaljit Kaur date है 4th February.
4th February.
300 petitions है 10-15 मेरी भी थी इस batch में. It was a very big batch after Rajiv Bansal in Delhi High Court. There are 2 important takeaways, Khivani ji, from this order. Many viewers today in this webinar and otherwise subsequently may be willing to understand what is the implication of this judgment of Delhi High Court disposing 300 petitions more than. Because what they have done, Puri Sahab, Justice Verma Sahab, they say there were various cases of various year, AY 13-14, AY 14-15, AY 15-16, AY 16-17, etc. What Justice Verma Sahab has done in para 27, you can note to para 29 of this Kanwaljit Kaur. His Lordship has said, I am remitting it back to the AO to pass a fresh order and interim proceedings will continue. And assessing officer ke samne, assessee can again raise the objections. And he has given direction that surviving period has to be calculated as per Rajiv Bansal para 112 and as per Delhi High Court another decision in Ram Balaram case. Meaning thereby, you have to compute the period between the date of issue of the notice in the old law till 30th June and then add it to the date when you have filed the reply after Ashish Agarwal and then see whether the new law notice is within that limitation. That is called as concept of surviving period, which is given in para 112 of Supreme Court Rajiv Bansal, which Delhi High Court Justice Bakru first applied in Ram Balaram and Justice Verma applied in this Kanwaljit Kaur. So AY 13-14 and 14-15 notices of June 2021, Khivani ji will be out.
इन्होंने एक फॉर्मूला देके सारे के सारी जजमेंट ठीक कर दी है एक फॉर्मूला.
I also feel that way. Second point, they have said that the assessing authorities are required to see whether the sanction was proper or not. Because in many cases, sanction is also not proper of AY 15-16. It is from joint CIT. It is to be from CIT. He has said Abhinav Jindal is one of my argued order of our Delhi High Court earlier order. He has said Abhinav Jindal applies even after Rajiv Bansal. And for AY 1516 sanction issue is also a live issue. So one aspect surviving period for AY 13, 14, 15, 16. Oh, 13, 14, 14, 15. For AY 15, 16 sanction aspect Abhinav Jindal. These are reproduced in the order of Kamaljeet Kaur. Ram Balaram case is reproduced, Abhinav Jindal is reproduced, and remit is done. Remit में दोबारा order pass होगा, again order will be passed. Third point.
But after verifying the requirements.
Yes, after taking the chart or after filing, after seeing what are the operative direction of the Delhi High Court in Ram Balaram case by Justice Bakru, after seeing the Abhinav Jindal sanction issue, then it has to be decided. For 1516, I am telling you, sir, there is a Rajasthan High Court order also and Delhi High Court order in Rohit Kumar. You can note Delhi High Court in Rohit Kumar, Justice Verma, and Rajasthan High Court in another case has said because revenue has given concession before the Supreme Court and notices of AY 1516 have to be dropped. And they are otherwise also barred by limitation as per 149(1) proviso. So 13, 14, 14, 15 Srivastava surviving period you have to see. 15, 16 sanction aspect and para 19 clause F of Rajiv Bansal. This concession of ASG has been to be seen. And Delhi High Court Rohit Kumar, Delhi High Court IBBO Limited, and Rajasthan High Court one judgment is there, which says that AY 1516 has to be dropped. So Puri Sahab, this is all about this what you say Kawaljit Kaur disposing 300 petitions. Rohit Kumar case needs a special mention. Rohit Kumar case facts it is, sir, in this case when the notice was issued in the old law, and said the High Court has said, Verma Sahab has said, since this notice of the old law of April 21 has to be treated as the notice now in the new law, and since amount is less than 50 lakh, it has to be quashed. Yes. You know what they say? That's very landmark order, Rohit Kumar. It says since the amount of the income escaping assessment is less than 50 lakh and the notice which was issued in the old law was in April 21, it has to be treated as the new law notice, and new law notice amount of beyond 3 years amount less than 50 lakh is to be strike down.
मगर कपिल तोला का confusion ही create कर दिया, किसी में तोला लग रहा किसी में नहीं लग रहा.
Sir, this confusion is not created by Delhi High Court, sir.
नहीं, that I know. but this is
Kamaljeet Kaur plus Rohit Kumar plus Ram Balaram. Ram Balaram is also very important order of Justice Bakru, where he has quashed a notice of A by 1314 after Rajiv Bansal saying surviving period ko add karke, if the notice is not within the limitation, then it has to be quashed. So our Delhi High Court 3 decisions I have submitted, sir. One Kamaljeet Kaur, second Rohit Kumar, and fourth Ram Balaram. One is my argued order, which has come on 15 January 2025 by Justice Bakru. You can all note this is Abhinav Jindal Part 2, Srivastava sir. Abhinav Jindal Part 2. AY 16.7 notice issued in 2024. Can it be said to be within limitation in the 6 years under 149(1) proviso? Delhi High Court Justice Vibhu Bakru says 6 years means should 6 years. And if 6 years is elapsed, wide first proviso to 149(1), then applying Delhi High Court Manju Somani earlier decision and Rajiv Bansal para 49. Delhi High Court in Abhinav Jindal 15 January says notice is time. So for 1617, if your notice is issued in 2024 after 6 years, that is 31st March 23, then notice is time barred, sir. So this is the fourth ruling after Rajiv Bansal. You know how much litigation is this? See, Abhinav Jindal 15 January 25, Rohit Kumar, this Kawaljit Kaur and Ram Balram. All these are after Rajiv Bansal, Khivani ji, post Rajiv Bansal litigation.
जी ये आपका पब्लिश नहीं हुआ शायद अभी तक अभिनव जिंदल
हुआ है सर, कहीं हुआ होगा, पता नहीं, मुझे नहीं पता सर. नहीं सॉरी, विद ड्यू रिस्पेक्ट, मुझे नहीं पता सर. अभी आगे बढ़ते हैं सर. सॉरी, आई वाज जस्ट सबमिटिंग one decision has come of Delhi High Court in case of Sonan's creations. This Sonan's creation 2 parts, part 1, part 2. It's a landmark order of Justice Bakru that how 148A exercise, show cause notice should be given, reply should be considered, and order should be passed. In summary sense, I am telling you, Puri Sahab, the Bakru Sahab and Delhi High Court and this Sonan's creation says if an allegation is leveled by the department against the assessee and assessee has denied that he has not done that transaction, then AO while making an order fit case has to apply his mind why the reply of the assessee is not right and why the information is worthy to reopen, Srivastava sir, which they 90% do not do at all. Sonan's creations, Delhi High Court Justice Bakru approach of one new kind of approach is new air is given to 148A by Delhi High Court in Sonan's creation. There was a Joginder Pal Gupta. Sorry?
केस का नाम दीजिए.
Sonan's creations. Sonan's creations.
Sonan's.
Yes, sir. Part 1, Part 2 argued by Agrawal Sahab, CS Agrawal Sahab, and written by Justice Vibhu Bakru, a new law 148A, that how step by step 148A should do very beautiful, and how 50 lakhs should be analyzed. 50 lakhs should not be in air. Puri Sahab, Sonan's creation is a landmark order on Delhi High Court of 148A. So now comes after this, all this 148A, Radha Madhav. I have got a order last day from Delhi High Court. It's worth reading. Order 7th February 2025, Radha Madhav states. You note it down. Very interesting order, Puri Sahab. In this case, a tax assessment took place, and it should be kept in mind that we have just discussed new law, new bill. Income tax officer, while making an assessment, Dharmender Bhai, of AY 67, considers the balance sheet of AY 78 and creates crores of demand. Assessee's bad luck was there. CIT appeal did not give any relief. ITT did not give relief. Srivastava Sahab, my entry into the picture happened when I filed appeal before Delhi High Court. Justice Shakdar admitted my appeal. On 7th February, Delhi High Court, while questioning this order, assessment order, saying it's not an irregularity, it's an illegality. They say, the Lordship Justice Verma says, if you have made a tax assessment on the wrong balance sheet, then it is a fatal flaw.
ये आपने भेजा आज पढ़ा मैंने.
To my mind, it's a very interesting order. I was not believing I will win it like this.
Very interesting. ये आपके facts ही गलत हैं.
And but it happens quite normally. The department considers wrong balance sheets, wrong final accounts, wrong thing. Has Shivani ji?
Yes. It happens a lot of times.
So these are all 148 developments. Radha Madhav, Abhinav Jindal, Rohit Kumar, Kamaljeet Kaur, Sanan's creations. Now I will just tell this Bombay High Court Hira Lal Malu case. Please note, sir, the real picture of tax department is being, sorry, I'm using this word, Srivastava Sahab, exposed in this order by Bombay High Court. You know, Puri Sahab, this is an order of 2025, just few days ago, by the tax bench of the Bombay High Court, where the issue was this: an assessee was raided, Malu Sahab, Hira Malu, his wife, and some jewelry was seized. And after all things being completed, Dharmender Bhai, the petition was moved from this assessee side, ki please release my jewelry. Can you imagine, Rajesh Bhai, what happened in this Malu case? Income tax department and bank where the jewelry was kept keep on blaming each other कि jewelry is not able to be located.
Jewelry गायब है.
And before the High Court says we are amazed that income tax department is saying we don't know anything. They are blaming bank. Bank is saying we don't know anything. Income tax department knows anything. And in this country, we are having a great tax culture. And the senior citizen, septuagenarian, has to go to the High Court for getting his jewelry back, for his wife late jewelry back. And then High Court has to remind the tax department what is this dharma and duty towards the taxpayer of this country. Is it not requiring some course correction?
And the bank says that we are not aware of what was in the locker. And the locker.
And Kamal, Srivastava, the line by Justice Sonak and Justice Jindal Sahab written that where this confidence is coming, this is quote unquote, where this confidence is coming to the tax authorities, that they are saying that we will do anything, but we will not be asked anything. ये confidence कहाँ से आ रहा है? ये जज कह रहे पूछ रहे हैं. ये कौन दे रहा है राजेश भाई? बाकी बिहारी दे रहे हैं, राधा रानी दे रही हैं. ये मैं नहीं कह रहा हूं, जज साहब पूछ रहे हैं कि इस देश के अंदर गलत काम करने के लिए कॉन्फिडेंस टैक्स अथॉरिटीज को कहां से मिलता है?
Because they are not challengeable, no? Accountability.
Anyhow, this order has been sent to the highest officials of the CBDT policy making body that the course correction should be done, and this kind of harassment for the people who are senior citizens who are going to the High Court and for getting their jewelry back, Srivastava Sahab, where bank and tax department are fighting with each other and they don't know where is the jewelry and poor man has to fight it.
अब होगा क्या इसमें? पैसे मिलेंगे क्या इस गरीब आदमी को?
लेकिन इसको लिख तो दिया.
ये ले गया यार, खत्म हो गया काम, क्या परेशान हो गया.
Anyhow, sir, एक और ऑर्डर डिस्कस कर देते हैं दिल्ली हाई कोर्ट का डिलॉयट हास्किन्स एंड सेल्स का नफरा के ऊपर. एनएफआरए, ये एनएफआरए बहुत इंटरेस्टिंग जजमेंट है, क्योंकि नफरा ने बहुत सारे लोगों को भी ऐसा किया है कि चार्टर्ड अकाउंटेंट्स को बोला कि नहीं वो गलत काम कर रहे हैं,
जिसमें नफरा को डांट पड़ी है.
हाँ, ये नोट कर लीजिए. डिलॉयट हास्किन का 450 पेज का फैसला जो जस्टिस वर्मा साहब ने लिखा है, 400 पेजेस से ज्यादा का फैसला. डिलॉयट हास्किन लीड मैटर है बैच मैटर में. कपिल सिब्बल साहब इनकी तरफ से अपीयर हो रहे थे, और जस्टिस वर्मा ने कॉन्स्टिट्यूशनल वैलिडिटी तो नफरा के प्रोविजंस की और कंपनीज एक्ट की अपील करी है, कॉन्स्टिट्यूशनल वैलिडिटी, बट ही हैज सेड नफरा हाउस इज नॉट इन ऑर्डर. राजेश भाई, all those notices which have been issued by NAFRA have been found to be legally defective and infirm by the Lordship of Delhi High Court Justice Verma in this 400-page order. They have been struck down. See the abuse of the law. They say this, the people don't know who has to do which job. And there is a very detailed paragraph here, Rajesh Bhai, written in this 400-page order. Predetermination. कि if an authority is acting with a predetermined mind, you are noting this word predetermination in Deloitte Hoskins. एंड खिवानी जी, इट्स नॉट एन ऑर्डर ऑफ कई, ये 7 फरवरी का ऑर्डर दिल्ली हाईकोर्ट का, जिसके अंदर नेफ्रा जैसी बड़ी अथॉरिटी के बड़े बड़े अधिकारी अपने को काम करने में समझ नहीं पा रहे हैं कि हमने कैसे नोटिस बनाकर देना है और किसको देना है।
और सारे नोटिस क्रैश करना बहुत बड़ी बात है।
इसका रेमेडियल अकाउंटेबिलिटी कहां है? उन ऑफिसर से कहां पूछताछ हो रही है भैया? वो कौन है? वो क्यों कर रहे हैं ऐसा काम? उनका क्या इंटेंशन है इसको तंग करने में चार्टर्ड अकाउंटेंट्स को?
वो तो श्री भगवान कृष्ण के छत्र छाया में है, उनके ऊपर तो कोई एक्शन होना नहीं है।
चलिए आगे बढ़ते हैं सर। ठीक है, ये डिलाइट हाउस के नोट कर लीजिए, 450 पेज का फैसला। उसका सबसे अच्छा पॉइंट मुझे श्रीवास्तव साहब प्री डिटर्मिनेशन और न्यूट्रलिटी के, उन्होंने जज ने वर्ड यूज किया, वर्मा साहब ने, अगर कोई अथॉरिटी बिना न्यूट्रलिटी के काम कर रही है राजेश भाई, वो काम ठीक नहीं है। न्यूट्रलिटी, न्यूट्रल इंपायर, न्यूट्रल, इम्पार्शियल, ऑब्जेक्टिव, एनी हाउस। इसने राजस्थान हाईकोर्ट ने अभी असेसमेंट इसमें 271 कैपिटल डी पे एक बहुत अच्छा ऑर्डर लिखा है सुनील कुमार अग्रवाल के नाम से, राजस्थान हाईकोर्ट, कि that if in an assessment order there is no satisfaction recorded to initiate penalty under 271D, in the writ petition Justice Avinash Jhingan in this Sunil Agarwal case, batch case, has quashed the penalty initiation in 271D for want of satisfaction in the assessment order, sir. This is a landmark order to my mind. Sunil Kumar Agarwal, writ petition, the penalty has been quashed, applying Supreme Court order in case of Khimani ji, Jay Lakshmi Rice Mills 379 ITR 5.
Yes, Supreme Court का order है वो.
हाँ, वो अप्लाई किया है उन्होंने उसको, सर।
हाँ, correct.
So,
that is being applied by Delhi Tribunal also.
Yes, sir. Yes, sir. And I believe I have covered fairly now 740. There's some questions if are there, Rajesh bhai, you can take them, 5-10 questions. Although I have tried to cover some of the important judgments and.
राजस्थान हाई कोर्ट की citation है क्या?
हाँ, yes, sir, है सर। सुनील कुमार अग्रवाल, सुनील कुमार अग्रवाल सर। That is सुनील कुमार अग्रवाल।
बनाकर किए गए।
If questions are there, Rajesh bhai, you can take it.
सुनील कुमार अग्रवाल.
I am telling you, just 1 मिनट दो मुझे दादा, क्या नाम अपना।
जी सर.
Sunil Agarwal versus Assistant Commissioner of Income Tax. Order dated. Badge matter. Order dated. I'm just telling. Order dated 30th January 2025. और last में I will definitely miss Rajesh bhai this order यार. तेलंगाना हाईकोर्ट, ये आज का लास्ट ऑर्डर है। सत्यम स्कैम we all heard. Very interesting case study for income tax. It's a case study, classical case study. Satyam case, the gentleman of that company, Mr. Raju, said we are doing fictitious entries in the book, Srivastav Saab, and they inflated the figures and they admitted it. There was a kind of a accounts maneuvering. After that, there was a lot of inquiries, proceedings in various laws, prosecution, criminal. In the income tax law, they revised their accounts and they pleaded to the CBDT under 119, you can note, Satyam, that their revised account should be considered while computing their income, not the accounts with fictitious entries. CBDT says no, once you have filed that account, you are bound by that. Even if they are fictitious entries, you have to pay tax on them. Now, Telangana High Court on 30th January 2025, speaking through Justice P. Shyam Koshi in Satyam computer case, represented by none other than Justice Mr. Arvind Datar, has written an essay on theory of real income and assessment on real income, and has said that entries of fictitious entries, Rajesh bhai, note it down. All fictitious entries have to be excluded while computing the taxable income is the finding of the Telangana High Court in Satyam case.
Where real income concept?
Yes. Even though you have done any immoral act, but income tax law is not considered with morality or immorality or good or bad or right or wrong. Demenderji, income tax act, this is a classical case of Satyam computers where the High Court has in the writ petition has interfered in the CBDT 119 rejection order that revised accounts should be taken care of while excluding fictitious entries. My point in this case is that this is the first of its kind order where an High Court has said fictitious entries in the books will not allow the department to compute income on the same. राजेश भाई, कैसा लगा ये वाला ऑर्डर?
वंडरफुल. इसको समझना पड़ेगा.
नहीं, मैं समझा रहा हूँ ना सर, समझना क्या पड़ेगा? मैं इसके लिए तो बैठा हूँ यहाँ पर, मुझे बताइए क्या समझना है.
हेलो,
हाँ, क्या बोल रहे तुम भाई?
जैसे फेक इनवॉइस है तो वो भी
शिवानी साहब कह रहे हैं इसके लिए एक वेबिनार और रखो.
फेक इनवॉइस का केस तो तरुण भाई, आपको एक ही बात बता रहा हूँ, अगर आपका बुक्स क्लियर है और आपके पास बिल वाउचर्स एंड ईवे बिल्स, ऑल डॉक्यूमेंट्री एविडेंस आर देयर एंड इट इज रिकॉर्डेड ट्रांजैक्शन, नो एडवर्स कैन बी इन्फ्रेंस कैन बी ड्रॉन. दादा आप ये समझ ले, फिक्शियस एंट्रीज मींस कि जहां आपने बुक बिल्डिंग करी हुई है, जहां डिपार्टमेंट खुद बोल रहा है आगे से कि यूर एंट्री श्रीवास्तव जी इज नॉट राइट. Still they are using it for income computing. That is not allowed. That is what Telangana High Court level, this is one of its kind order. That fictitious entries cannot be made as basis to compute the income in the income tax act. डिपार्टमेंट तो fictitious entry के ऊपर भी 68 लगा देता है.
वो तो क्या
नॉर्मली एसएससी वो जितनी एंट्रीज को जस्टिफाई करने की कोशिश करते हैं, कभी ये नहीं कहते कि हमारी बुक गलत है.
जैसे आपको एक एसएससी को कहा कि वो एंट्री प्रोवाइडर है, लेट अस से अजीश भाई वो इधर से लेकर माल दे रहा है, वो एंट्री का काम कर रहा है, उसके अंदर आप उस एंट्रीज को एक्सक्लूड करना पड़ेगा. तेलंगाना हाईकोर्ट चलेगा तो. हिमानी जी, अब समझ में आया या दोबारा समझाऊं?
नहीं समझ आया.
ये जो जैसे जो अलंकित वाले मैटर्स हैं, इसमें फिर सेम चीज लग जाएगी. अगर आप
भाई अलंकित वाले मैटर्स में तो ओनर्स डिपार्टमेंट ने दादा डिस्चार्ज ही नहीं करा कि जिस आदमी ने उसका स्टेटमेंट रिकॉर्डेड है, जो भी गुप्ता जी हैं वो क्या है.
सुनील कुमार.
मुझे याद है सर, वो भाई साहब क्रॉस एग्जामिन हो, उनका कॉरोबरेटिव एविडेंस आवे, तब तो 153C का प्रोसीडिंग दादा जस्टिफाई होगा. ऐसे कैसे हो जाएगा? उस पर कर्नाटक हाईकोर्ट का एक लैंडमार्क ऑर्डर आया है, आप पढ़ लीजिए, सुनील कुमार शर्मा का, जिसको सुप्रीम कोर्ट ने अप्रूव कर दिया है. लैंडमार्क ऑर्डर है वो 153C पे.
सुनील कुमार शर्मा,
कर्नाटक हाईकोर्ट, सुनील कुमार शर्मा,
ओके,
अप्रूव्ड बाय सुप्रीम कोर्ट ऑफ इंडिया. दैट 153C में कोई भी डॉक्यूमेंट मिल रहा है तो उसके लिए भी कॉरोबरेटिव एविडेंस चाहिए. और जब तक ये रिट में क्वेश कर दिया था 153C कर्नाटक ने, और उसको सुप्रीम कोर्ट ने कहा सही क्वेश किया था.
ओके.
153C का मेरिट्स पे कर्नाटक हाईकोर्ट सुनील कुमार शर्मा अप्रूव्ड बाय सुप्रीम कोर्ट इज द लैंडमार्क ऑर्डर. बत्रा जी आप इसको पढ़ लीजिए. सुनील, वो जो आप अलंकित वाला बता रहे हैं, आपको अलंकित वाले पूरा लगेगा वो.
राइट सर.
आप समझ गए मैं क्या बोल रहा हूँ?
मैं समझ गया सर.
ये सारे प्ले करते हैं आपस में, कोई ना कोई कहीं ना कहीं से कोई रेशियो निकाल लेते हैं.
हाँ, ये आशु जी क्या पूछना चाह रहे हैं सर? इनको इनका हाथ खड़ा करवा दो यार, ये बहुत सारे क्वेश्चन पूछते रहते हैं और इनसे अलग से चार्जिंग लिया करो. क्या बोल रहे हैं हमारे प्यारे भाई? In case of a joint property sale, owner's husband and wife is a housewife, payment was done from their joint account. Should the TDS deducted on both or just husband? In case both, then IT will ask wife. सर ये आशु भाई टिपिकल प्रैक्टिकल क्वेश्चन है. आप इसमें बेस्ट परमुटेशन कॉम्बिनेशन लगाइए जिसमें आप डिपार्टमेंट को समझा सके अपनी बात. सीधी सी बात ये है दादा.
कपिल भाई, इसमें रिसेंटली तो दिल्ली हाई कोर्ट की जजमेंट आ गई ना, शिवानी मदान.
यस करेक्ट.
शिवानी मदान की
अभी
जजमेंट आई है.
मैं ये पोस्टमार्टम स्टेज की क्यूरी नहीं है, प्रिवेंटिव स्टेज की क्यूरी है श्रीवास्तव जी. स्टेज क्या है क्यूरी की? उन्होंने क्लैनिंग करनी है अभी. मैं आप जजमेंट बता रहे हो वर्मा साहब का जो लिखा गया है, आई एम वेल कॉन्शियस अबाउट इट. I am telling you that in case of a joint property sale, owner's husband and wife is housewife, payment was done from their joint account. Should the TDS be deducted on both or just? See, TDS चाहे एक का कटे चाहे दोनों का कटे. आशु जी conceptually समझ लीजिए. If there was a joint property, then both of them are required to show the as per law in section 45 read with owner definition. क्यों पूरी साहब? Respective share has to be disclosed by them.
Yes.
And for practical purposes, TDS is deducted in one, then does not matter. Then it does not change the substance of the transaction. Form substance will prevail.
तो क्लबिंग प्रोविजन ही खत्म हो जाएंगे फिर तो.
नहीं, जो जिसकी ओनरशिप है वो उतना उसका रिस्पेक्टिव शेयर रहेगा सर.
शाह साहब, आस्क योर क्वेश्चन प्लीज. शाह साहब.
सॉरी सर, मेरा गला भी दर्द हो रहा है. राजेश भाई, मेरा गला बड़ा आजकल, ये ना क्या आपका नया लॉ आ गया ना, ये लोग अभी 8-10 दिन से मेरे को लगातार ये सेमिनार चल रहे हैं.
राजेश भाई एक काम करो, इनके क्वेश्चंस ले लो और कपिल को फॉरवर्ड करो.
नहीं सर, मैं अभी बता दूंगा सर, अभी बता दूंगा सर. हाथ क्या मैं
शाह साहब प्लीज आस्क योर क्वेश्चन. शाह साहब प्लीज.
आप बोलिए सर. सॉरी.
पूछ लो कपिल भाई, मैं पूछ लो क्वेश्चन.
सर
मुरुगेसन सर, प्लीज आस्क योर क्वेश्चन.
एक सर्च में मेरे एसएससी का पकड़ा गया कुछ अकाउंट. अकाउंट इज कि we have purchased furniture for something like 3 crore rupees.
Oh, furniture of 3 crore. Furniture of 3 crore.
Yes.
I'm rightly hearing.
Yes.
पर्सनल है.
To be precise, it is 2 crore 70 lakhs.
आगे
राउंड फिगर बोल रहा हूँ.
मैं समझ गया, कोई बहुत बड़ा आदमी होगा जो. हाँ ठीक है, समझ गया सर. हाँ.
अच्छा, तो उसने क्लियर कट बाइफिकेशन दिया हुआ अकाउंट में, एक्सेल शीट में, कि जिसमें हाफ बाय चेक हाफ बाय कैश. बड़ी क्लियर कट डिस्टिंक्शन दी हुई है. ए बी टोटल इज दिस मच. अच्छा, अदर फैक्टर्स अपार्ट.
फर्नीचर परचेज किया. सॉरी खिमानी जी, आपको इंटरव्यू कर रहा हूं. मेरी आवाज आ रही है? मैं आवाज आ रही सर राजेश भाई?
यस बॉस.
मैं ये पूछ रहा हूँ खिमानी जी कि जिससे फर्नीचर परचेज किया है वो आइडेंटिफाइड
हाँ हाँ, कंपनी बकायदा, one of the leading manufacturers of interior decorators and other things. तो
जिससे
they are doing it in various other cases, 8-10 parties का भी
तो
पकड़े
उन्होंने
गए।
क्या, उनके यहाँ क्या हुआ, उनके हैंड उन्होंने, सॉरी, उन्होंने क्या कहा सर, सेलर ने, फर्नीचर सेलर
सेलर ने एडमिट कर दिया कि हम नंबर 2 की सेल करते हैं जी, ऐसे ऐसे करते हैं, वो तो एडमिट कर दिया ड्यूरिंग 130 रिपोर्ट।
आपकी आवाज कट रही है, सॉरी, क्या कह रहे हैं,
हाँ,
क्या कह रहे हैं, सॉरी,
ड्यूरिंग 132(4), ड्यूरिंग 132(4), एक मिनट, कैसे नॉइस आ रहा है?
Somebody a background guys.
हाँ, कोई धर्मेंद्र भाई आवाज नहीं आ रही ढंग से ना,
अब
हाँ,
आ
कोई
रही है।
बीच में किसी का शायद आवाज आ रहा है, पीछे से किसी के माइक ऑन है, तो पीछे से किसी के बच्चे की आवाज आ रही है।
चलो अब ठीक हो गया,
हाँ सर, बोलिए बोलिए बोलिए।
आगे प्रोसीड करते हैं। तो क्लियर कट डिस्टिंक्शन दी हुई है, पूरे अमाउंट का आधा आधा किया हुआ, इवन टू द लास्ट रुपी,
दिस डॉक्यूमेंट वाज फाउंड फ्रॉम होम,
फ्रॉम द फर्नीचर मैन्युफैक्चरर,
फ्रॉम सप्लायर और फ्रॉम द बायर,
फ्रॉम द
सप्लायर
सप्लायर पे अकाउंट पकड़ा गया जिसमें लिखा है कि साहब 2,70,00,000 का मैं फर्नीचर बेचूंगा, 1,35,00,000 चेक से लूंगा, 1,35,00,000 कैश लूंगा। अब इसमें 1-2-3 क्वेश्चन अदरवाइज तो हैं कि अकाउंट कैसे है, लूज डॉक्यूमेंट एक्सेट्रा, मगर आईटीओ
आप
सेसिंग
किसके हैंड
ऑफिसर
में
ने
पूछ रहे हैं, सप्लायर के हैंड में पूछ रहे हैं, बायर के हैंड में पूछ रहे हैं,
बाहर के एंड में,
ओके, मतलब थर्ड पार्टी हो गया, उस पे सर्च नहीं हुआ,
थर्ड पार्टी पे सर्च नहीं हुआ,
जो जिसने
मेरी थर्ड
फर्नीचर
पार्टी,
परचेज किया,
हाँ।
ठीक है, आगे बढ़ाइए, मैं समझ गया सर, हाँ।
तब जब उसने आईटीओ ने एडिशन की है तो उसको सेक्शन 69C में कर दिया।
सर देखिए, पहला पॉइंट ये है खिवानी जी,
मैं थोड़ी सा आगे एक पॉइंट और रेज कर लूं, फिर आप करिएगा।
हाँ हाँ, बताइए बताइए, सॉरी, हाँ।
सेक्शन 69C इज फॉर एक्सपेंडिचर। तो मैंने डिस्प्यूट किया कि मैंने जो कंपनी ऑफ फर्नीचर खरीदा है दैट इज एन इन्वेस्टमेंट बिकॉज इट इज डिक्लेयर्ड एज अ फिक्स्ड एसेट। तो सेक्शन 69C
अब
इज नॉट
मैं
एप्लीकेबल।
आई गॉट द कंप्लीट स्टोरी सर, नाउ अंडर, एक कागज पेन लेके आप नोट करें जहां आप नोट कर रहे थे। माय हम्बल पॉइंट इज दिस कि जिस सेक्शन में उन्होंने जुरिडिक्शन एज्यूम करी, वो कौन सा सेक्शन लगाया, एक्सप्लेनेशन टू 148 या 153C?
एक्सप्लेनेशन
डायरेक्ट 148 दिया आपको।
हाँ जी।
तो पहले उसके लिए जो क्लॉज 3 और क्लॉज 4 में जो सेटिस्फेक्शन नोट रिकॉर्ड हुआ और अप्रूवल सैंक्शन, वो आपको सप्लाई किया उन्होंने, पहला
मुझे किया, उसके डिफेक्ट्स अलग है,
हाँ ठीक, उसके डिफेक्ट लगे, अच्छा,
उसके
अब
डिफेक्ट
आप
अलग है मगर, और
ठीक है,
सेकेंडली नॉट गिवन विद द 148 नोटिस गिवन सब्सिक्वेंटली ऑन माय रिक्वेस्ट।
हाँ, तो वो गलत है, वो सब फैटल है। दूसरा पॉइंट, यू आर राइट, मतलब वो हमने पहले भी डिस्कस किया था दिसंबर में। अभी दूसरा पॉइंट इसमें दादा ये है कि जिसके यहाँ डॉक्यूमेंट मिला, आप सेक्शन 292 कैपिटल C नोट करिए, जिसमें ये लिखा हुआ है कि जिसके यहाँ से जो कागज मिलेगा, प्रिजम्पशन उसका उसके ऊपर ही होगा, थर्ड पार्टी पे नहीं हो सकता है। आपको मैं सिंपली बता रहा हूँ, जैसे जिसके पास से जो कागज मिला, उसका प्रिजम्पशन कि ये सही है, ये उसी के ऊपर ड्रॉ होगा जिसके पास से वो मिला, मीनिंग देयर बाय द डॉक्यूमेंट evidentiary value is against the person from whose possession it is found, that is written in section 292 capital C of the Income Tax Act. Now your assessee is not such assessee from whose possession it is not found, so no evidentiary value the document against your assessee. Point number 1. Point number 2, if department has to bring that document to your assessee, it has to make 2 bridges. One bridge is to have that document corroborated, which Supreme Court says in this Karnataka High Court, I am telling this Sunil Kumar Sharma judgment, which I told to other person, and it's approved by Supreme Court. And secondly, you have to have the statement of the gentleman from whose this search take place, and he has to come and cross-examine himself. Department has to bring him in the proceeding of your buyer assessee, that he has admitted that he has supplied this furniture and taken cash in unaccounted cash. So this exercise department, I'm afraid, has not done in your case while making addition under 69C, that this furniture supplier was not brought in the proceedings of the buyer of this.
No, it was not.
So sir, that is a fatal error.
And we have called for the cross-examination. Now what happened was, another interesting thing happened. When we appeared before the commissioner, तो वो कहता है जी अरे ये तो विड्रॉ कर चुके हैं स्टेटमेंट, ये कब?
तो सुप्रीम कोर्ट जिंदल लिमिटेड, you note down, landmark order of Supreme Court Jindal Limited 460 ITR directly applies to you. That was a case in which a Reliance was a company involved, and Reliance case there was an addition of this expenditure, bogus expenditure on accommodation entry on statement of some Mr. S.K. Gupta statement, and which was not cross-examined and which was already rejected also. So Supreme Court Justice Ujjal Bhuyan said if a statement is used and this S.K. Gupta statement is used which is not cross-examined and which is retracted later on, then addition and assessment is totally null and void. This Supreme Court of India, Jindal Limited. Jindal Limited 460 ITR 460.
460.
Yes, this is a landmark order. You can note it.
ठीक है, करिए.
And 292C, one thing, cross examination another thing, corroboration another thing.
क्या मेरी contention ठीक है कि इस पे section 69C is not applicable? So the CIT agrees.
It is hairlining, you know, it is hairlining. From perspective of the investment versus expenditure, there is a fine distinction. As an accountant, we understand expenditure is an outlay. Supreme Court says in Indian Malice. An investment is an act where you do an investment, you for getting this something out of it. So I'm afraid it is investment as such, even though your book entries may be saying book entries are not conclusive to taxation. I'm afraid, but you can definitely toe this line. Maybe you can have this some luck on this, but it is a very hairline.
मगर खिवानी
It
जी,
should be added under.
आप
The commissioner agrees. It should be under section 69A. Under section 69.
I am already understanding your point, sir. I told you
Yes.
there is a fine
So-
difference between investment and expenditure. I understand.
चलो.
Correct. Correct.
So,
Anyway,
but you have to make a stronger argument on cross examination, corroboration, and this 292C.
वो
Yes.
सब लिया है, मगर I was only discussing this fine line. वो सब issues लिए हैं.
And Sunil Kumar Sharma
Jindal
का
Limited I would take. सुनील कुमार शर्मा.
चलो.
ठीक है.
राजेश भाई.
प्लीज सर, बहुत बहुत धन्यवाद. एंड ओवर टू अतुल पुरी सर. My throat is not working properly. So
Like
over
me.
to Atul Puri sir.
But let me conclude with one Ramcharitmanas Chopai, sir. Sorry.
Yes sir. Yes sir. Yes,
please.
I am sorry. I have especially noted for this today's session this Chopai. This particular Chopai I have noted for this session, Rajesh bhai. Because whenever हमारा सेशन होता है, मैं उसके लिए कुछ ना कुछ अपना सोचता रहता हूँ कि मुझे आप बोलने का मौका जरूर देंगे. When एक अगस्त मुनि थे जो रामचरितमानस में, जब राम जी उनके पास गए तो उनके एक शिष्य थे जिनका नाम था शुतिशन, और उनको पता चला राम जी जब मिलने आ रहे हैं खिवानी जी, तो उन्होंने रामचरितमानस में श्रीवास्तव साहब उसको कैसे प्रकट किया उस बात को. मोरे जिए भरोस दृढ़ नाही, मेरे को भरोसा नहीं हो रहा. भक्ति विरति ना ज्ञान मन माही, मेरे में तो भक्ति भी नहीं है, ज्ञान भी नहीं है. नहीं सत्संग जोग जब जापा, ना तो मैंने कोई सत्संग किया, ना जप किया, ना कुछ किया. नहीं दृढ़ चरण कमल अनुरागा, ना मैं उनके चरणों का कोई अनुराग कराए मैंने कोई ऐसा. फिर भी एक बाणी करुणा निधान की, सो प्रिय जाके गति ना आन की. इसका मतलब ये हुआ, श्रुतिशन जी ने कहा कि ये वो राम जी हैं जिनका कोई भी सहारा नहीं है, तो भी उनके ऊपर वो दया करते हैं. ये श्रुतिशन जी के वचन है राम जी के लिए. और एक और सॉरी, एक और मैंने राजेश भाई, जब भरत जी ने कहा पुलक शरीर सभा भय डाडे, नीरज नयन नेह जल भाड़े, कहब मोर मुनिनाथ निबाहा, एही ते अधिक कहा मैं कहा. इससे ज्यादा अधिक मैं क्या कहूं. जो भरत जी की वंदना थी वो यही थी कि जो राम जी है वो हमारे सबसे इंपॉर्टेंट देवता है. और लास्ट में सर, भगवान कृष्ण के लिए यही बात निकल के आई कि राधिका किशोरी संग रमन तिहारा, मुझको दिखा दो कभी प्रभु ऐसा नजारा, फिर चाहे मैं मर जाऊं छिपाकर तुम्हें आंखों में, बसा के तुम्हें आंखों में. सर थैंक यू.
पुरी साहब. पुरी साहब,
ज्ञान तो मिलता ही है, भक्ति का ज्ञान भी मिलता है.
नहीं सर, ये जरूरी है सर. इसके बिना हमारे को अंदर ना कुछ किया ना कर सकूं, ना कुछ करने योग्य, जो कुछ किया हरि आपने, आप ही करने योग्य. और बार बार वर मांगा हूं, हर्षि देऊं श्री रंग, वज सरोज न पायनी, भक्ति सदा सत्संग.
बहुत बढ़िया, बहुत बढ़िया. कपिल भाई, एज ऑलवेज वेरी एनलाइटनिंग. इतने थोड़े समय में आपने सारा निचोड़ निकाल दिया है, और आपकी बात बिल्कुल ठीक है कि अब हमको इसके लिए वेट करना पड़ेगा. अभी इसके ऊपर डिस्कशन होंगी, कई अमेंडमेंट्स होंगी, कई चेंजेस होंगी. उसके बाद वंस इट इज बिकमिंग ए लॉ, प्रेजेंट के असेंट मिल जाए, नोटिफाई हो जाए, उसके बाद हमको एक्चुअली प्रैक्टिकली पता लगेगा कि व्हाट ऑल दिस लॉ इज अबाउट. और आपके बात बिल्कुल ठीक है कि इन्होंने जो चीजें करनी चाहिए थी, जो उनकी कहनी है, वो करने में नहीं आ रही है.
करने में फर्क आ रहा है.
They should have accountability. They should have real tax.
एक पन्ना मैंने पुरी साहब उसके ऊपर पूरा लिखा है, आप लोग पढ़ के उसका फीडबैक जरूर दीजिएगा कि जो मैंने सजेशन वाला बनाया 12 पॉइंट है उसमें.
नहीं, वैसे वो सजेशन जो है हम अपनी कोशिश करेंगे फोरम के पहुंचाएं. भैया ये
कपिल, एक चीज, एक छोटी सी ऑब्जर्वेशन मैंने की. असेसमेंट में तो ले आए वो फेसलेस असेसमेंट, पर अपील स्टेज के लिए वो वो enabling provision लाए हैं, मतलब scheme to be framed.
ठीक है, अच्छा सर,
मतलब
अब
we
इसमें
have
तो कुछ तो
meaning
सस्पेंस
दे भाई,
रखेंगे ना। आप
meaning दे भाई
तो
कि
मेरे से ज्यादा
उन्होंने
जानते हैं।
surrender कर दिया।
देखिए, आप हमारे में
इसमें
सबसे विद्वानों में से एक श्रीवास्तव साहब एक हैं, और हमारा, मैं बड़ी विनम्रता से कह रहा हूँ, बड़े प्यार से, आपको ये बात समझ में ज्यादा आएगी मेरे से या हमारे से, कि ये जो गवर्नमेंट का जो ये लॉ बनाने का तरीका है या स्कीम लाने का, कुछ तो सस्पेंस मिस्ट्री रखेंगे ना। अभी 2026 के बाद भी तो गाड़ी चलनी चाहिए, हमें ध्यान तो रहेगा अभी क्या होगा।
नहीं, मैं ये नहीं कह रहा हूँ, मैं तो ये कह रहा हूँ कि the government has surrendered before the forum of commercial appeals.
ठीक है सर, अब क्या कर सकते हैं। ये तो कितनी हाईकोर्ट कहे,
सरेंडर कर दिया उन्होंने कि भाई ठीक है, आप जो कर रहे हैं हम आपको कुछ नहीं कर सकते, आपका
तो हाईकोर्ट कह ही
आपके
नहीं
अगेंस्ट कुछ
सकता।
नहीं कर सकते।
आपके सामने जब 8-8 साल तक अगर लोगों को न्याय नहीं मिलेगा, तो आप वर्ड
हाँ।
न्याय यूज करते हैं। आपने,
हाँ।
मैडम ने, ऑनरेबल फाइनेंस मिनिस्टर ने न्याय वर्ड यूज नहीं किया पैरा 134 में।
हाँ, हाँ।
भारतीय दंड
अब वो
संहिता से भारतीय न्याय संहिता की जब बात हुई और कहा कि नया इनकम टैक्स लॉ न्याय की तरफ होगा, तो न्याय कहाँ आया?
न्याय है ही नहीं।
है नहीं हो सर, ये बात कंप्लीट।
आप ये देखिए, वो इंटरेस्ट एसएससी को अभी भी, वो एसएससी को जो रिफंड पे इंटरेस्ट देना है वो अभी भी 6% चलेगा।
अनिल, इनका ना एक पैट फॉर्मूला है, टू बी फ्रेम्ड, टू बी नोटिफाइड एट ए लेटर डेट। तो ये जो है ना, ये इनका कुछ पता नहीं है। अब आप देखते जाओ
तो जिंदल साहब जैसे नहीं कह रहे थे मजाक में कि कपिल गोयल जैसे वकील क्या करेंगे? अरे भाई, बाकी बिहारी जो हमें देंगे हम तो खाएंगे तो वही।
यार, लिटिगेशन तो कम हो ही नहीं
नहीं,
सकता।
हम लोग कंप्लायंस में भी, ये लिटिगेशन जरूरी नहीं है, कंप्लायंस एंड एडवाइजरी भी इज अनदर फील्ड जहाँ पे हम लोग अवर रोल कम्स इन।
अनिल जी, जहाँ
कपिल जी,
होगा।
सर, मुरुक सेन बोलिए, मुरुक सेन जी।
Yeah, for the assessment year 2015, notice was issued on 7/4/22. The income escape prescribed in the notice
Sir,
was.
can you repeat? Can you slowly repeat what you said? Sorry.
For assessment year 2015-16, notice under section 148 was issued on 7/4/2022.
Got it.
With escape income for 70 lakhs.
Okay.
Okay. And till the SOCAS notice was issued, the quantum specified was only 70 lakhs. But in the assessment order, the addition was made for 2.02 crores. So tomorrow, we have filed a
2 point, Murup Senji, 2 point. You, this reopening, Murup Senji, would
Yeah. Reopening 2.02 crores. Yeah.
Can I give my answer, sir? Can I give my answer?
Yeah, one second. Tomorrow the matter is coming. We have filed a writ. So tomorrow the matter is coming for hearing before the Honorable Madras High Court.
Okay.
So because last week we filed one writ petition challenging 148 issued for the assessment year 15-16 on 11/4/2022. He said that time you are having is 10 years. The notice is valid. So it is coming before. It is coming before the same judge tomorrow. So he will say the notice is having jurisdiction.
You can note two things, sir. One aspect is humbly I am telling you, sir, you are my senior. One, Muruk Senji, you can section 149 subsection 1 first year time limit. Para 49 of Rajiv Bansal case by Justice Chandrachud 469 ITR page 46 para 49. How 6 year has to be applied, you can see that. In my humble opinion, and read with my decision of this Abhinav Jindal of 15 January 25, you can take an argument. If the notice of 15-16 is issued in April 22, it is time barred. The time barring date was 31st March 2022. Are you noting?
Could you please repeat? I will note down.
Two judgments I am citing, sir. One judgment is of Supreme Court of India, 3-judge bench, Union of India versus Rajiv Bansal, 469 ITR, page 46.
Page 46. Okay.
Para 49. Para 49.
Para 49. Yeah, excellent.
Where Justice Chandrachud has very beautifully analyzed the implication of first proviso to section 149(1). That outer limit of 6 years has to be seen.
Yes.
So 6 year time limit expires on 31st March. First proviso to 149. So third and fourth proviso cannot apply. It should be your argument.
Yeah. First proviso of section 149 will apply. Yeah.
And not other provisos.
Yes.
And secondly, you can rely upon our Delhi High Court latest order by Justice Chandra, this Vibhu Bakru Saab, Abhinav Jindal, 15 January 2025 order.
Abhinav Jindal.
And then you can try to develop an argument. So it's not reported, I'm sorry. It's reported in live law. You can check live law.
Okay.
And second argument, Dada, you can just take, brother, You can,
Yeah.
brother, I am saying you in a humble sense.
Yeah,
don't-
no.
So you can take this argument that if there is a variation between the final assessment order and the 148 notice and order, then the entire proceedings are flawed. There is a Delhi High Court decision in ATS infrastructure.
ATS infrastructure. Okay.
And
Okay.
latest order of Delhi High Court, Subhash Chandra Dabas, 5 December 24.
Subhash Chandra.
Dabas, 5 December 24.
Okay. 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 Okay.
So 2 arguments you can develop, and third you can also see, sir, whether this Sonan's creation point, Sonan's creation is a judgment of Delhi High Court. I told now.
Delhi High Court. Yeah. Just
This is
now.
Yeah,
that, that how department has invoked 148 on the wrong facts and incorrect facts and baseless facts.
Yes. Yes. Yes.
So
Okay.
these 3
Okay.
things, Moruk Senji, come to my mind. I have given in humble manner. Maybe I'm not an
Thank
authority,
you.
but I'm humbly telling.
Thank you. Ji. Thank you. Ji.
Murgeshan,
Yeah.
share your email ID. I'll forward you at least Abhinav Jindal
Yeah.
and Sonash Creations. These are readily available with me. I can
Yeah.
forward
I will share
the
the
copy of
email ID.
judgments.
Yeah. And similarly,
your
we
email.
got one favorable judgment.
Yeah, just share the ID.
1400 Yeah, I will share my ID, boss.
Yeah.
Okay.
Until
And
Ram Ram,
Madras High Court, we got challenged surviving period concept, and we got a favorable order in one case.
Great, sir. Great. Excellent. God bless you.
Okay.
Pranam, sir.
So Kapil
Thank
bhai,
you. I will share my ID. Ji. Okay.
Yeah,
Thank you so much.
Gupta A2000 at Yahoo.
Puri ji
very
क्या
much.
कह रहे हैं? Puri साहब क्या कह रहे हैं?
मैं कह रहा हूँ, coming back to vote of thanks, thank you so very much. A lot of deliberation, lot of, mind you have applied, and it has made our job easy. And these case laws that you gave 6 + 4 are amazing. और आजकल यही केसेस चल रहे हैं सबके, यही केसेस चल रहे हैं, क्यों अनिल जी? है ना? तो ये बहुत बहुत यूजफुल है, और एक रेशो से कई केस निपट जाएंगे.
सर मुझे
सर, ये
नहीं आता
recent
जाता है.
मेरे-
ये आप लोग मुझे यहाँ बुलाते रहते हो, मेरे को कुछ आता जाता बिल्कुल नहीं है, और मेरे को कुछ समझ में भी नहीं आता. मेरी बुद्धि काम बिल्कुल नहीं करती है.
प्रभु जी, अगर अभी आता जाता नहीं तब ये हाल है, तो जब आप जाओगे तो ज्ञानी हो जाओगे तो क्या करोगे? नहीं, रियली थैंक यू वेरी मच. और भाई आप गले का ध्यान रखो. टेक गुड केयर ऑफ योरसेल्फ, यू आर वेरी प्रेशियस, एंड थैंक यू वेरी मच फ्रॉम ऑल ऑफ अस. इतने पार्टिसिपेंट मैं तो पहली बार देख रहा हूँ. 400 से ऊपर पार्टिसिपेंट थे.
सर.
More than 450, sir.
I am blessed by the institute, sir, and the chartered accountant, sir.
ऐसा इट इज योर, आपका कहना है कि लोग इतने खिंच के आते हैं. हम तो देखो, हम तो आपके मुरीद हैं ही हैं, आपको इतना प्यार करते हैं. बाकी देखो 450 मेंबर्स जुड़ने, ये इट इज ओनली योर नेम.
सब ये मैंने क्या कहा, ना कुछ किया ना कर सकूं, ना कुछ करने योग्य, जो कुछ किया हरि आपने आप ही करने योग्य.
बड़प्पन आपका, ये भी बड़प्पन है. थैंक यू वेरी मच, and thank you very much all participants. It was a great deliberation.
और हमारे तंजानिया के दोस्त धर्मेंद्र भाई को भी स्पेशल थैंक्स, सर.
हाँ,
थैंक यू कपिल जी. I have